Oh, let it go. That's underway.
Thank you. Okay, good morning, everyone. Sorry for the slight delay there. We're just overcoming a few IT issues, as is the norm with virtual proceedings. This is day 9 of the Sanquhar 2 wind farm inquiry. So today's session is of 2 hearing sessions, and today's focused on energy and planning policy matters. There are 1 or 2 new faces or names on the screen, so by way of introduction, my name is Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, the DPEA, and I've been appointed by Scottish ministers to hold this inquiry. Can I check you can hear me okay so far? Audio's all good, excellent. So, as you'll no doubt be aware, the whole of the inquiry is being live streamed on the DPEA webcast site, and a recording of each day's proceedings can also be viewed there. So by participating today, you're consenting to the recording, storage and use of this material for webcasting, training and for the keeping of records that are accessible by the public. Now, before I go any further, can I first of all confirm who's taking part in this session? So go to the applicant first, please. Mr. Hardy, please.
Yes, good morning. I know it's sunny behind me. I don't know how dark I'm appearing, probably appearing as some sort of agent of darkness by the look of it, but I hope you can see me. So it's going to be myself and then David Bell from David Bell Planning. We are going to be the principal participants. I mean, I don't know how formal the procedure is going to be. My experience of these hearing sessions is that you know, it can vary. If there are things which are detailed and outside the ken of both of us, then there may be some other team members, and I would just say at the appropriate time, look, would it be all right if somebody else chipped in? But principally, it's going to be myself and David Bell.
That's helpful. Thank you, Mr. Hardy. Good morning to both of you. And for Dumfries and Galloway Council, Mr. Robinson and Mr. Armstrong. Mr. Armstrong, I can see you speaking, but I think you're muted.
That's correct, sir. I'm appearing for Dumfries and Galloway Council, along with Andrew Robinson, the Senior Planner at Dumfries and Galloway Council. And also we have Peter Ferguson, Solicitor and Partner of Harper MacLeod, instructing agent.
Thank you, Mr. Armstrong. Good morning to you all. And then Mr. Campbell, please, for Stop Sanquhar 2.
Good morning. I'm representing, as before, Stop Sanquhar 2, this time with Mr. Christopher Ford. And there are just the 2 of us today to participate in the hearing.
Thank you. Good morning to both of you.
Thank you. Good morning.
Is there anybody else on the call that was expecting to be participating today, but I haven't given a chance to introduce themselves? I wasn't expecting anybody else. Okay, excellent. So, in terms of the format, it is different to previous days, as you would expect. So as it's a hearing, we'll be having a discussion that I'll lead. So there'll be no need for you to repeat your full cases to me. I'll be structuring the discussion based on the agenda that was circulated on the 14th of September. Can I check you all have sight or a copy of the agenda? Yes. Great. So we've had a supplementary hearing statement from the Stop Sanquhar 2 group and the applicant's response to that as well, since I prepared the agenda, and a few extra documents too. But I'm satisfied that matters raised there can be weaved into our discussion, principally under items 1 and 4. So I'll invite particular people to contribute at appropriate times, but I'd welcome relevant comments and questions from any participant today as the discussion progresses. So I would ask that if you have questions, these should be put through me, please, if possible. I'll indicate as well when I want to move on to a different matter. Now, one of the challenges, obviously, in virtual sessions, and particularly hearing sessions, where several people may wish to speak at once, is that we can't make eye contact with each other, and I can't read your body language as easily either. So it would help me a great deal if you could keep your video on if you're actively participating, and raise your hand when you wish to speak. Just indicate to me. And if you're intending, so then if I've missed you, please then just turn your microphone on and tell me if it looks like I'm intending to move on at any point and you haven't had the chance to say what you wish to say. Is that clear? Does that sound like a reasonable approach?
Yes.
It is a challenge, unfortunately. In this respect, hearings are actually more difficult, I think, than inquiries for sort of virtual purposes.
Mm-hmm.
So we have the whole day available. I don't think it's likely we'll need the full day, but we'll see how we progress. We'll take a break midway through the morning. And if we need to break for lunch, we'll do so at a convenient point between 12:30 and 1 p.m. For an hour. So is everyone clear about what I've outlined, just in terms of how we're going to progress? Yeah. And does anyone have any questions or any other matters that they'd like to raise before we move on to the first item on the agenda? No? Okay, lovely. Okay, so if I can draw your attention then to the agenda. Item 1 is entitled European, UK and Scottish Energy and Climate Change Legislation, Policy and Targets. And got a few questions around this, a few points that I'd like to discuss. I think it might be helpful, whilst I don't, as I said in my introduction, I don't want to hear kind of full cases presented to me at this stage, but it might be helpful if I could ask Mr. Bell and perhaps Mr. Hardy, if you want to contribute as well, to outline the main reasons for your position that increasing weight should be given to the output of the proposed wind farm. Mr.
Yes.
Bell.
Well, I'll hand over to Mr. Bell,
Hardy.
and then if there's anything else, then I'll sweep up. Thank you.
Lovely.
Thank you. Yes, clearly the hearing statement covers matters in some detail, but if I could maybe just take a few minutes to outline probably the key points why that I think support that proposition.
Yeah, I think that's helpful because I think that'll then give the other people who have a different view to
That's fine.
Possibly challenge that.
That's fine. I think the first point I would say is that in terms of the question that you posed, shifting emphasis or change in energy or climate change legislation or policy, there's certainly, I would say, a shifting emphasis. That's my simple answer. And there have been changes to legislation. And in terms of planning policy that we'll come on to, that's clearly drawing from that wider canvas of energy policy, we know that there is impending change. I believe the NPF4 draft comes out in a few weeks, in November, and next week there will be a draft onshore wind policy statement, which will examine spatial planning. So we're at a cusp of policy change that's catching up with the changing emphasis and changed legislation. So I think that's an important point to just acknowledge at the start. I think also 2050 and 2045 are key dates for net zero for the UK and Scotland. But 2030 is very much being seen as a tipping point and is coming into sharp focus for all of us with COP26 and the use of energy and the massive increase in electrification that is to come is clearly on the agenda. It's on our television screens most days. But to try and ground that in some key documents before the inquiry, the first reference I would make is to the changed law, which is the arising from the Climate Change Emissions Reductions Target Scotland Act 2019 that amended the Climate Change Act. And in my hearing statement, I've set out a table, which, just to give you the reference on that, is page 53, that sets out the government's targets running up to 2045. And it's evident that there's a ramping up of the targets through the 2020s. And we can also see that in the data that is available for 2018 and 2019, the targets have been missed quite considerably for emissions reduction. And that is not policy, that is the law now, and clearly very different to what is in SPP, which talked about moving to a low carbon position. Clearly it's net zero. It's not gross zero, it's net zero that we're aiming at. And the related point to that is in terms of the sixth carbon budget that set out how we get to that position of emissions reduction. And that's before the inquiry is CD 010.023. It's now set in UK law as of June this year, which limits greenhouse gas emissions for that budget period. So it limits what the UK can emit within a defined 5-year period. Now, in all the scenarios that are set out in the Committee on Climate Change document, there is a role for onshore wind. They're in all the scenarios between 20 and 30 gigawatts of capacity by 2050. And the other important document that grounds the emissions reduction and the need for electrification is the Energy White Paper to CD 010.013 that and maybe a quick way to communicate my point is in my hearing statement at page 49, there's a bar chart that shows the energy use 2019, and it contrasts that against the future. And you can see the massive increase in electricity use by 2050. And we know from the analysis in these documents that that's driven by the fundamental changes to transport, the move to EVs, industrial and building space heating, very topical in the last few weeks with the discussion about removing gas boilers and moving to electric air source heat pumps. And a lot of my work over the last few years for the Energy Catapult in providing local area energy planning advice has been very much about how the UK can shift to electrification of heating in buildings, given there are a very significant amount of emissions that come from buildings. We've done very well in the energy sector. That's largely decarbonised or on the way. Still some coal in use on occasion, like West Burton, but that's a real success story. There's still a lot of gas being used, but it's buildings, and that will come from electrification. That's what the white paper is telling us. Related to that, that policy document is I would just highlight two additional points. One is the AR6 report from the Intergovernmental Panel on Climate Change, and I've drawn upon the UN Secretary General's statement that it's a code red for humanity, and that will be the backdrop to COP26. Now, bringing matters from that sort of global stage down to the Scottish position, the latest insight we have into the Scottish Government's thinking on this, on how our government officials, how government is acting on this, is the Programme for Government and the Butte Agreement that has been struck between the SNP and the Green Party. And that's in the inquiry as APP 001.001, just agreed in August and formalised in the Programme for Government in September. And it has statements on energy and planning. And in terms of energy, page 12 of that document sets out that the climate emergency means, this is just if you can quote for just a minute to set that out, it states, we believe the climate emergency means we need to use the limited powers we have to accelerate the decarbonisation of energy system. While electricity has been largely decarbonised, our plans will see a significant increase in electricity demand for heating and transport. To accommodate this, we will support the continued and accelerated deployment of renewable energy. In order to do this, the parties state that they will set an ambition to deliver, subject to consultation, between 8 and 12 gigawatts of additional installed onshore wind by 2030. This will be supported by changes in the planning system needed to permit the growth of this essential zero carbon sector. So the changes in the planning system, we will see in a few weeks what that fundamental rebalancing of the planning system will be. But this is the first time the Scottish Government has moved to a technology-specific target for the land use that we are dealing with at this inquiry. Previously, the RO was technology agnostic. There was no banding of support by technology, but we're now moving into that. After all that, just to close it, you would say, well, how does that affect the decision making in this case? How does it affect one striking of the balance? Now, we'll perhaps come to, there's an additional document which is the UK net zero strategy, which just came out a few days ago. Well, I don't want to talk about that too long at the moment. So I would just say in conclusion that if we look at some decisions, and they're not that recent now, they are a few months ago, before some of these matters have come out. But what I sought to do in my hearing statement, in terms of how decision makers have tried to grapple with this, because this is not the first time this has been discussed in an inquiry or an appeal context, but I thought there were three particularly helpful decisions. One is Millenderdale Farm, which is an appeal decision notice, CD 011.004, where the reporter recognised that what the appellant was saying was right, namely that the more recent material considerations increased the value that should attach to renewable energy benefits. Secondly, Paul's Hill 2, inquiry report by Mr. David Bowyer, which is document 011.015 from July 2020, where there is reference to the changed legal position, the new emissions reduction law, and importantly, at my paragraph 2611, I've set out a quote from the inquiry report where what the reporter does is say, look, we've got SPP, but the position has been strengthened by additional publications, policy and strategy documents. He then gives further support to the net zero position, and then further support again because of the position that the Committee on Climate Change was setting out. The last document I think is helpful is Crystal Rig, inquiry report CD 11.028, where the reporters in that case said that the development also attracts support from recent developments in the response to the declaration of a climate emergency. Now, that was back in January 2021, and things have moved on again since then. So I think I've probably spoken enough. What I'm saying is not a carte blanche for every project that's coming forward. That would not be correct. But it does, in my view, add weight to the benefits of the development or any development that is coming forward, subject, of course, to development management review. But in my view, it is a matter that should be afforded great weight for these reasons. Thank you for letting me speak on this point.
Thank you, Mr. Bell. So Mr. Bell's outlined there that essentially the energy policy and strategy position has that shifting emphasis and a more positive emphasis on schemes such as the proposed development. I'd like anybody's responses to that, particularly any contrary views to it. Mr. Armstrong.
Thank you, sir.
Mr. Harding.
I wonder if it's just helpful just to finish up one sentence, really. in terms of the applicant's case, and it's this that's all very helpful. I think it's important to recognise that in response to your question, that the dial has already shifted. So if the starting point is the sort of business as usual scenario, it isn't a case that this is all forward looking and something is going to happen, that the dial has already shifted, but for the reasons that Mr. Bell has given, that the dial is going to continue shifting and potentially accelerate at the rate at which it shifts. So the appeal decisions given are very helpful because they indicate that in the last 12 months. So what we're not wanting to do is give a picture that somehow this is off in the future and is going to happen. It has happened and is happening already. So I think that's just worth bringing those strands together. Thank you.
Okay, thanks, Mr. Hardy. Sorry to cut you off, Mr. Armstrong there.
No, not at all. Mr. Robinson will have the main response in relation to this question. I think it would probably be helpful, though, to have one document to hand, which Mr. Robinson is going to refer to, and that's CD 1136, which is the Galt Clay wind farm decision. But I'll pass over to Mr. Robinson in relation to the council's response.
Just bear with me a moment then whilst I get that document in front of me as well. Others can as well. It was 1136, Mr. Armstrong. Yeah, that's right.
That's correct, sir, and it will be principally paragraphs 273 to 285, pages 32 to 34. That I think there'll be a reference to. It is obviously a very long decision.
Yes.
Right, I'll pass on that. I'll pass over to Mr. Robinson.
Yeah, thank you, Mr. Robinson. What would you like to, or how would you like to respond for the council?
In respect of responding, obviously I've covered renewable energy policy in section 4 of my hearing statement. And I think the first thing to say is that the council doesn't dispute that there is the targets that are set in legislation, obviously, and the recognised need to get to net zero, and supporting decisions that will achieve that in appropriate locations, though, and that's the key thing. I've referred in my hearing statement to a number of different measures that are available for reducing emissions, such as heating systems, improving home energy efficiency, reducing vehicle pollution. Onshore wind energy obviously is going to contribute to achieving net zero targets, but I think it's important to emphasize that it's not going to be the only technology that's going to help us to achieve there. And in my hearing statement, in paragraph 4.7.2, I've referred to the National Audit Office report. That's CD 010.014. And in paragraph 1.9 on page 21 of that document, it recognises that all sectors of the economy need to consider how to decarbonise, with reference made to harder to decarbonise sectors such as aviation and shipping. So I think Mr. Bell said that the power industry has made great strides in working towards net zero, but there's obviously it's highlighted there that there's other sectors that also need to contribute to that. So in terms of how that links into the shifting, whether it shifts balance, of all of these documents that I've referred to in my hearing statement, I think there's a thread that this has to be balanced against environmental considerations, and the goal to say decision, which we've already given the document reference to, in particular, paragraph 2.73 to begin with. The reporter stated, "I'm not persuaded that the Scottish Government did intend any diminution in the protection of the environment or its importance in the balance, even upon introduction of the new targets." And there's a number of paragraphs there which I won't recite all of them. Obviously, everyone will have them to hand. And paragraph 2.85, I think, is quite key here. And it says, "Minister's decision on the proposed development must be taken with the increased emission reduction targets in mind. However, I still do not find it to be a necessary implication that an effect on the environment that was unacceptable before either the enactment of the 2019 Act or the recognition of the global climate emergency has become acceptable as a consequence of those events." And his recommendations in the report are made on that basis. And obviously, in that case, it appears that the reporter considered that the landscape and visual impacts of that scheme were acceptable. Obviously, we're all waiting for the publication of the draft NPF4 document. Mr. Bell has referred recently to sort of government or political statements that seems to give us an insight into potentially what may be coming forward. And in terms of the Scottish Government and Scottish Green Party shared policy programme published in August, obviously this was a draft document, so it is draft at this stage, and in respect to the reference of 8 to 12 gigawatts that's referred to on page 14 of that document, it does say it's subject to consultation. And again, page 14 of that document states that we will deliver an NPF4 that actively enables renewable energy, supporting repowering and planning for the expansion of the grid with local community input throughout the planning process, and which recognise the global climate emergency as a material consideration for appropriately located renewable energy development. So there is that emphasis there and reference to appropriately located developments. And then turning to page 17 of the programme, it actually states that it will actively enable renewable energy, including solar power, supporting repowering of existing wind farms and planning for the expansion of the grid, recognising the global climate emergency as a material consideration for appropriately located renewable energy developments, and revising the national spatial framework for onshore wind so that developments of national parks and national scenic areas are not supported. And
I think, sorry to interrupt you mid-flow, Mr. Robinson. I think we might touch upon NPF4 later in the agenda. So
yeah,
I'll
stay. Yeah,
energy policy side of things.
Yeah.
So I think in terms of your position there, where you essentially kind of recognise the importance of projects such as Sanquhar 2, but it's not at any cost. That's your position.
That's the position, and it's clear that there has to be a detailed consideration of the environmental impacts of the proposal.
So on that point, there might not actually be anything between you and the applicant in terms of recognising that. Obviously, the applicant has a very different view on the scheme itself, but and the merits of that. But in terms of the actual overarching position, would that be a fair comment, Mr. Bell, that your position would be, well, yes, there is this ramping up of need and importance, but it's still not at any cost.
I think that's broadly right, Art. There's a few points I'd just like to respond to Mr. Robinson on, but I think the key thing is if the need case is increasing, and we know how that's being articulated by government, Mr. Robinson's right, it's to be consulted on that target between 8 and 12. So it might end up at 8, it might end up at 12, but there will be a target. Then if we know that there's already established capacity, and if I put it crudely, many of the easy sites, if I can put it that way, have been taken up, all the obvious sites, and we're now looking at additional wind development to be put in place. We know the government's telling us, look, you're not going into national parks, you're not going into national scenic areas. They've given us very clear spatial guidance so far on Group 3 areas in which this site sits, where wind farms are likely to be acceptable, subject, of course, to detailed review. And I think Andrew and I are consistent on in agreement on that. But the bar of acceptability has to shift somewhat in that if you are to accommodate additional development, if the need case has grown and has materially changed, which I would say it has, and with all due respect to the Galtaclay decision making that was back in the very start of 2020, I think it's quite clear to me that things have changed. But the planning system must be, decision makers need to be responsive to that. To simply say, we accept all that need case, but nothing has changed in terms of where development can go or the level of harm that might be acceptable. I think that's the key issue that the decision makers need to grapple with.
And Mr. Hardy, just a quick one, please, and I'm going to ask Mr. Campbell and Mr. Ford for their contributions.
Yes, well, hopefully contribution will be very short on this. It seems to me the acceptability in the number of moving parts that you have in the decision-making process, the bar of acceptability is the only variable integer. So when you look at decision-making of the sort that's in Galtaclay, and you hear, well, if it was unacceptable before the various bits of legislation and policy changed, I find that very difficult because the character doesn't change, impact on visual amenity doesn't change. What does change and can and must change is the appetite to accept such changes. And I think it's, I have to say, it's probably a phrase I heard Mr. Campbell use about 10 years ago, and it was this: that if you're going to make an omelette, you've got to break some eggs. And the point is that if the omelette is going to be bigger, then there has to be a decision potentially to break some more eggs. And I think that really encapsulates the case, acceptability, and that's why we've been so clear about separating out impact analysis from the test of or the threshold of acceptability. It's only that acceptability bar that can move.
Thank you, Mr. Hardy. Mr. Campbell and Mr. Ford, I don't know who I should come to first. So, Mr. Campbell, I'll ask you, and then if you'd like to hand over to Mr. Ford, please feel free.
Yes, thank you. I'll do that. The discussion has shifted slightly from the way the agenda is set out to looking...
As is always the way.
As is always the way. I do have 4 quasi-legal points, which I'd like to put to you, but I'd like to defer to Mr. Ford first to see what his response is to what David is saying, what David Bell is saying, and then perhaps I'll come back.
Good morning, sir. First of all,
morning.
Let me agree with Mr. Bell and Mr. Hardy that the emphasis is shifting. However, I fear that I'm not going to agree with them much beyond that. Let me first of all pick up on the Scottish Government policy, the recent policy that Mr. Bell's just outlined. Obviously, these are political ambitions, not policy as such, and we wait to see what the policy will be. The other thing to say about that is, like lots of political ambitions, they do face the reality of the day-to-day activity and the day-to-day situation. Having said that, nothing that I've seen in the recent Scottish Government statements actually changes the fundamental position about judging the local merits. Now, I hear Mr. Hardy and Mr. Bell talking about shifting the balance of acceptability and phrases like capacity, this balance has to shift. Not sure that's true. And I think I'm going to disagree with them at that point. And the reason is because fundamentally there are alternatives. There are alternatives to this proposal. There are alternatives to other proposals. We will, I appreciate, come back to those alternatives later on the agenda. But that doesn't, just because the need is for dealing with climate change doesn't necessarily presume that this proposal is justified and that balance has shifted. The other, and probably the most important document that Mr. Bell certainly referred to, but we ought to put into much more focus here, is the recent government's net zero strategy. For kind of two reasons, really. One is this is the start of the implementation of the Energy White Paper, which has been referred to. But secondly, there's an issue about order and precedence here. We're obviously dealing with energy policy. Energy policy is a reserved matter under the Scotland Act 1998. And therefore, UK government policy, in a sense, takes precedence here. And we've obviously seen situations where, and I think Mr. Bell alluded to it, in the latest government agreement, where the Scottish government is working with limited powers. And we have to accept that. And we have to accept the precedence of the UK government policy. But if you look at the net zero strategy, and it's obviously a long document, and I appreciate it was only issued a day ago, 2 days ago. But from my quick reading of it, I think there are two salient points that this inquiry needs to recognise. The first is that actually, if you do a word search on it, the phrase onshore wind does not appear at all in the whole of the document. Offshore wind appears, solar appears, gas with CCUS appears, BECCS, which is biomass with carbon capture, appears. New nuclear appears, both in terms of large-scale nuclear such as Hinkley, or another 1 or 2 sites for that. Small modular reactors appear as well, and hydrogen all get very strongly featured. But onshore wind is entirely omitted. This is very important, and it's also very stunning in terms of an omission. I've been trying to think back to the last major broad sweeping energy document where onshore wind has been omitted. And I think you're thinking back to the early 2000s, kind of more than 15 up to 20 years ago. So this omission is actually quite a striking change and a fundamental shift in policy. So I think there are two kind of conclusions for this in terms of just that omission itself. The first is that the UK government does not see a need for further onshore wind developments. And that, frankly, is a stunning observation. The second point is, and this goes back to the general picture about the meeting the need, is that the UK government is saying that the energy transition can reach net zero without further onshore wind development. In other words, they're taking it out of the picture completely. The second general point that you can make about the relevance of net zero to this proposal comes back to this day-to-day reality, this day-to-day practicality, and the fundamental question about the deliverability of the energy coming out of this proposal. The applicant's talking about 308 megawatts. The question is, can that be used to meet climate change? And the second issue that's coming out of the net zero strategy relates to the government's view of large-scale transmission grid infrastructure within the whole GB. On page 99 of the strategy, it says a new approach to offshore and onshore electricity networks will be applied. And they're talking about the concept of removing the need for transmission infrastructure. They're talking about moving to much more embedded-based generation so that electricity is generated close to demand centers. And they're also talking about using onshore wind connecting to the grid, the existing grid, without further substantial transmission grid infrastructure. Now, I suspect we'll come back to it later on the day, but I'm sure the applicant is aware that there is a major problem using energy from onshore wind farms in Scotland. We can come back to the details of that. I'm also happy to give, perhaps a little bit later on the day, perhaps some of the insights that I think are driving the UK government's view of why it has dropped onshore wind energy completely out of the net zero strategy. And that relates to this issue about transmission infrastructure and trying to get the deliverability of the energy to the consumers. I'll leave it at that point now, and I'm happy to take up any of those points. Thanks very much.
I'm sure there will be points to be made to that. I was conscious Mr. Campbell wanted to raise some points as well, but just before I hand over to you, Mr. Campbell, just looking at the net zero strategy. So, yeah, obviously it's a long document and we haven't had long to study it. But I've just got it open in front of me now. I'm looking on page 94, where there are key commitments around power, and the third bullet point down says deliver 40 gigawatts of offshore wind, including 1 gigawatt of innovative floating offshore wind by 2030. Are there any wider points, though, that, I mean, in terms of taking those commitments in the round? So the first one, take action so that by 2035, all our electricity will come from low carbon sources, subject to security of supply, etc., fully decarbonised power system by 15 years. Is that clearly offshore wind isn't the only part of that solution? Nuclear is referred to there. There are other technologies referred to. I suppose my question is onshore wind assumed to be part of that equation in this strategy?
Perhaps I can answer that, sir. I don't believe it is.
Okay. No, that's...
If we look at some of the things like the white paper, and to be frank, this change of direction has been, well, for people like me that, if you like, are anoraks on this kind of stuff, I think it's been evident actually for about 15 to 18 months. And it is kind of, there was quite a strong hint in the energy white paper, but there was a kind of passing remark about transmission infrastructure, but it was very heavily qualified by being aware of cost to consumers. And one of the problems with the transmission infrastructure issue is that the cost fundamentally falls to consumers. And to be frank, if you're going to develop a wind farm, or rather more wind farms in Scotland, and we're in a position where the energy demand in Scotland can already be fully met by the existing onshore wind farms when the wind's blowing. So the energy is therefore flowing beyond that. Surplus energy is flowing outside the Scotland into England, essentially. The problem is that boundary has a capacity of about 5 gigawatts. It sometimes drops much lower than that, particularly when the Western Link, Western HDV circuit drops out, which has been out for this year. It's been out for 4 months out of month 10 now. So, you know,
okay,
40% of the year kind of thing. So there is a great challenge in getting the energy out and delivered. And essentially the UK government is looking at the position of saying, you know what, because of that cost to consumers, which is we have to remember here under the Electricity Act, under Section 3, I think it is, there's a requirement on both National Grid, on the regulator, Ofgem, and on the UK government to minimise cost to consumers. Essentially, in terms of the choice between, for example, offshore wind and onshore wind, say from this proposal, because the surplus of supply, the issue is that the energy from this proposal, if it's going to flow southwards, has to requires basically new infrastructure, which has got to be paid for by consumers.
Okay, Mr. Ford, I'll stop you there for now because I think that's straying into different territory in terms of cost and transmission. So we'll just pause there.
Many thanks.
Thank you, Mr. Campbell. Do you want to make your points now, and then I think everybody else has had their hands up at some point, so I'll come to you all.
Yes, thank you very much. Can you hear me all right?
Yes, thank you.
Yes, thank you. There are 4 points to be made following what Mr. Ford has said in my submission, and this is really just as an aid memoir for you, sir.
Thank you.
And obviously for ministers. Firstly, as Mr. Ford has said, energy policy is a reserved matter under the Scotland Act. And so this is obviously an energy inquiry. And that will mean that you will have to look at UK government policy in relation to the generation of energy. Whether or not you can give UK energy policy precedence over Scottish government policy is a matter for submissions, but we will say that you should. The second point is that the Electricity Act 1989 is, of course, a UK statute. And so, on one view, Scottish ministers are acting under a delegated power, which is given by that statute. Ministers, and the recommendation that you make, sir, need to appreciate that you're taking this decision, or that they are taking this decision, in a UK-wide context rather than just in a Scottish context. Understandably, and with great skill, Mr. Bell has focused on land use policy in the papers that he has submitted. That is what we're all trained to do, and focus in the inquiry sessions thus far have been on land use. But there is a wider picture which, with respect, you need to be aware of. Now, thirdly, we are aware that the electricity which might be produced by this development, if it's consented and built, would flow out of Scotland. And so, for the reasons already given, you need to be mindful of the situation in respect of electricity and energy use in the rest of Great Britain. Luckily, you have before you very up-to-date policy statement in that regard, not simply political aspiration, but as somebody said a minute or two ago, the beginnings of the implementation of the white paper commitments. So the capability of the energy system to transmit what is to be generated here is, in my submission, a factor to which you will have to give weight. Now, as if to support that, and this is the fourth point, the electricity system across the United Kingdom is regulated by UK-based entities. The regulator, Ofgem, is a UK-based entity. The electricity system operator, or ESO, otherwise the National Grid, is a UK-based entity. So the policies, both in operation and in regulation, of these bodies are crucial to the operation of the electricity system here in Scotland. This is a much more complicated picture than the Scottish Government would have us understand. It is not simply a matter of saying there is a climate emergency, therefore we must generate as much renewable energy as possible. That, of course, is an easy political take on the position for this application. But it's more complicated than that. And I tried very hard to put it in the simplest terms possible. There's no point in this application being consented if the electricity has nowhere to go. Mr. Ford has explained in the inquiry statement about the constraint boundaries and transmission issues and so on, and I won't revisit those here. But remembering, as we all must, that the core legislation is UK-wide legislation, you need to look as widely as you can in this inquiry and not simply focus on land use policies. Now, sir, I don't want to give evidence. That's really a submission, or a quasi-legal submission, as I put it earlier. I think I would defer to Mr. Ford if there's anything to add, but we perhaps have exhausted the point for the moment.
Thank you, Mr. Campbell. Well, I'll hand over to Mr. Armstrong. I saw you have your hand up, and then I'll move on to Mr. Bell. So there's a lot. Obviously, there's a lot there to consider and to potentially respond to. In your responses, Mr. Armstrong and Mr. Bell, I'd like your views on in terms of whether UK policy should take precedence in this instance, and if that's the case, does it differ, and if so, how does it differ to Scottish energy policy?
If I could start, and it was really just wanting to correct Mr. Bell on one point to start off with, and then I'll go over to Mr. Robinson to deal with the second point and the extent of agreement between Mr. Robinson and Mr. Bell. And then if I can come back perhaps on the third point and just briefly deal with the policy position. But if I can first of all just correct one point that Mr. Bell said. He referred to the Galt Clay decision at CD 36 and said, oh, well, it was at the beginning of last year. But of course, the decision of the Scottish ministers, which adopted the approach set out by the reporter, is actually this year. And it's the 24th of March, 2021. And I refer to that, bearing in mind the recent Court of Session decisions where they've confirmed the expectation of consistency of interpretation and, to an extent, the application of policy from decision makers, and in particular the Scottish ministers. So I refer to that as a key decision of the Scottish ministers. This is in fact this year's. We can all go through the recent decisions. Cornharrow, CD 1133, paragraphs 71 to 86. A similar approach has been taken by a Scottish minister's reporter recently, again this year, considering these matters. That's the 1st of June 2021. So I'd submit that in relation to the recent decisions, that there is a consistency of approach, and that approach doesn't sit particularly comfortable with what Mr. Bell was saying earlier. In relation to the extent of agreement or disagreement, if I can just pass over to Mr. Robinson on that.
Thank you, Mr. Armstrong. Yeah, Mr. Robinson.
Yeah, I think I would just like to basically finish by saying that has there been a shifting emphasis? And if there has been a shifting emphasis, that would indicate that more weight has to be given to renewable energy benefits of the scheme, in such that the landscape and visual impact or other environmental considerations of the scheme or a proposal have to be given less weight. And in my opinion, I don't see anything in the documents that are in force at the moment, or anything that's coming forward in the documents to suggest that that will be the case. So in summary, our view is that the balance hasn't changed such that environmental considerations have to be given less weight in decision making.
Thank you, Mr. Robinson. And Mr. Armstrong, you were going to pick up the last point.
Yeah, and on the last point, my learned friend Mr. Campbell is absolutely correct in relation to the 1989 statute, and that it is delegated. The decision is delegated to the Scottish ministers in this case. But ultimately, it is up to the decision maker to decide what weight to attach to any particular policy, whether it be UK policy or Scottish policy. And that is a matter for the decision maker, unless the statute specifically sets out that a particular degree of weight should be given to a particular policy. But ultimately, that remains a matter for the decision maker. I think that's the only point I would make in relation to my learned friend's points at this stage.
Thank you, Mr. Armstrong, and I could see Mr. Campbell nodding at that point as well, so that's noted. Mr. Bell, please. Again, yeah, there's quite a lot there, obviously, to potentially cover. So I'll let you do it in whichever order you consider appropriate at this stage.
Thanks. I'll try and keep it fairly brief. I think in terms of the UK policy position, there are clearly some legal points around that, which I will leave to others. But certainly, I would agree that UK government policy is material and is in play, and that's important. I think one factual position to correct. I mean, I've done a word search of the net zero strategy, and it may be that there's different documents in circulation, but I have onshore wind referenced on my page 103 of the document. So we need to be very clear on the facts that are being put or so-called facts put forward here. and it's a very clear reference to rooting that in the carbon budget, the 6th carbon budget, which is now set in law. And in my introduction to this topic, I referenced the 30 up to 30 gigawatts of onshore wind that is referenced in all the scenarios in the carbon budget. So I think Mr. Ford is simply wrong that the UK government doesn't see any role for onshore wind, which I think is a very extreme position and is clearly at odds with the Scottish government position as expressed in their more recent documents. Now, the other references within the net zero strategy, I could cover that now, or happy to do that later. But certainly, you know, what one key one is on page 19. I think it's the executive summary under power key policies. Bullet 3. 40 gigawatts of offshore wind by 2030. We always knew that offshore wind was to have a big role, and that was foreshadowed in the white paper very clearly. But it says 40 gigawatts of offshore wind by 2030 with more onshore, solar and other renewables. Now, a clear interpretation of that is that there's ground-mounted solar and onshore wind within that. And the likelihood is that the onshore wind will come forward in Wales, where the new National Development Framework, which is now part of the National Development Plan, in the same way that the NDF has been, you know, approved by the Senate and is in force, is very supportive of onshore wind. And there's new policies put in place to guide that. And the Scottish Government is clearly going down that route as well in terms of land use planning policy, which is not a reserved matter. And that is set out in the position statement, and that will come forward in the new development plan in the form of the NPF. We also know from the white paper that we talked about at the start that onshore wind is referred to as a key building block of the route to net zero. So it is clear on a very reasonable and clear reading of the documents that there is a role there for onshore wind. And there's other references within the net zero statement. In terms of the point about the planning balance, I think Mr. Robinson was coming on to just as he finished. I think the point is that it's relatively more weight is to be given to a certain matter. Now, whether it's wind energy or housing need or some other land use type, if it's decided that there is more weight to be placed on a certain matter, that has an effect in dealing with a planning determination. And we all know that if you're placing more weight on something that is a good thing that you want to approve, then of course you look at the effects. But you know, if you're facing a position where it's very finely balanced and there's enough of a land use type and there's some impact, you might say, well, look, on balance, there's simply limited need and I'm placing limited or just moderate weight on that matter and I'm going to refuse planning permission. But if you're faced with the same development coming forward and the need case has increased, then you're placing more weight on the benefits, and what would have been a refusal 6 months ago may be an approval. And I don't need to put that into a wind context. It could be any type of land use that's coming forward, where the planning decision maker needs to strike a classic planning judgment on the material considerations in front of it. And that was what I was saying at the Galticley inquiry to the reporter, that we don't need to wait for an express direction from the Scottish ministers to say planning officers must place more weight on a particular matter. That is a planning judgment. Now, it may be that in a few weeks' time, when we see how the Scottish Government is rebalancing the planning system, that they may say things like, well, within Group 3 areas, you must place very substantial weight on benefits that come forward that deal with climate change. I don't know. We'll need to wait and see. But that is really what I was trying to get at and how that relates to the striking of the planning balance.
Mr. Hardy, I'll come to you in a moment. Mr. Ford indicated that he wanted to respond to something Mr. Bell had said there. So, Mr. Ford.
Thank you. Just a few quick points. First of all, the Climate Change Committee budget figures are, of course, recommendations. They're not actually government policy. They're just suggestions that the government could do. And by listening to the news commentary by the CCC this week on the net zero strategy is that they accept the strategy. And obviously it's for the government to implement the strategy rather than the CCC. In terms of the white paper and the building blocks, there's a perfectly valid interpretation that building blocks referred to in the white paper, and obviously we've moved on with the net zero strategy since then, but the building blocks could be interpreted as being the existing wind farms represent the foundations for what's going to happen in the future. They don't need to be building blocks in terms of building the solution. They might just be the foundation points. Thirdly, in terms of the onshore wind referred to in the net zero strategy, it's just an example, and there's no specific tying to Scotland in that. It's just a sweeping situation across the UK. And if you look at other points, as I've already said about the net zero strategy, there are clear indications in that the transmission issue is something that the UK government is going to consider. And if you look at it in detail, they're actually talking about changing the transmission charging system, which to me is pointing towards increasing charges in Scotland for onshore wind farms. I can come back to explain that later, sir. The other fundamental point that Mr. Bell doesn't respond to at all is that he hasn't answered this question about what's going to happen to the electricity coming from this proposal. And in terms of the last point, in terms of the planning changes that he's mentioning, absolutely right, the planning changes that are coming forward might say all sorts of things. We don't know what they're going to say at the moment. We have to respond to them as and when we know what they are, not in terms of political ambitions. We know that political ambitions are important, but at the end of the day, many political ambitions never get achieved. Mr. Bell already said himself that the energy targets have not been achieved. So we don't know whether that's 8 to 10 gigawatts, what it's going to be or anything. So for this state of play with this decision, we have to take the policy as it is. Thanks very much.
Thank you, Mr. Ford. On that last point, in terms of the energy targets, are they not? They're more than policy, aren't they? Though they're set in law.
Absolutely, yes, certainly. They're statutory obligations. I mean, you can use terms like law, and that's valid. You know, law covers all sorts of things. We're not supposed to kill people and all that kind of thing. The law is a very sweeping generalisation. We know that this is actually administrative law, and as such, as we've seen with other examples, and we won't get into the whole issue of Brexit and that kind of thing, but we know that the government can change the law. So it's a statutory obligation. We should respect it as a statutory obligation, but also understanding that you know, we might not meet the target. Just because it's a statutory obligation doesn't mean to say it's going to be delivered. I mean, to be frank, I've been working in climate change for many years now, and it would be lovely to see it happen. And I'm sure everybody on this session thinks that's a good thing, but it doesn't mean to say we're going to get there, unfortunately.
Okay. Thank you, Mr. Ford. Mr. Hardy, please.
Yeah, yes, I mean, a number of points. I don't recognise the world that Mr. Ford sees at all. I'm afraid I think he's misinterpreted from the very top. I'm just one point that I think he needs correcting on, and that is to take you to page 45 of the Energy White Paper. And I don't need to go to it now, but you know, in your leisure, so to read it. And it says this: the onshore wind. So onshore wind and solar will be key building blocks of the future generation mix, along with offshore wind. And then it says this: we will need sustained growth in the capacity of these sectors in the next decade to ensure that we're on a pathway that allows us to meet net zero emissions in all demand scenarios. So that does not mean a building block that's there and you don't do anything about it. It means you have it now, it's a cornerstone, and you need to expand that in the next decade as one of the 3 key cornerstones of generational policy. That's you. Well, I see Mr. Ford shaking his head. That is what the Energy White Paper says on page 45. Now, clearly, Mr. Ford wants to take a different view. It's a matter for submissions, but that is what the UK government has said at the highest level of policy in the white paper.
And we've moved on from that, with all due respect, Mr. Hardy. We now
Well,
have the net zero energy strategy.
We don't, with respect, the strategy doesn't overarch the energy white paper in the hierarchy of policy, as I'm sure you'll be, you know, your advocate will do within submissions. The energy white paper trumps that strategy, Mr. Ford. That is the highest level of policy articulation, and it's quite clear about what's there and what's required over the next decade in terms of onshore wind.
It doesn't say where the onshore wind energy would be, and the white paper is also pointing towards, and we've seen this fulfilled in other documents such as the flexibility plan that we submitted just in the last 2 weeks or so, that the transmission complex situation is an issue.
My point was a simpler one, so it was this, I think you've got it, that Mr. Ford was, it's easy when you don't look at documents to listen and believe that's what's said. And Mr. Ford's point was that the references in the energy white paper to what's there, that's quite wrong. It's a misreading of the white paper.
Thank you, Mr. Hardy. And Mr. Ford, I do understand the point that you're making. So
Thank you.
I've got that noted. Thank you. Okay. So under item 1, I think I might have actually exhausted my questions because you've actually managed to cover them in what you've been telling me over the course of the last hour. Just bear with me a moment though, because I don't want to move on without and find I've missed something. Yeah, so there are aspects of what we've talked about there that we will be coming back to, obviously, as we progress through the agenda. But are there any points that you think that you may not have an opportunity to raise again under the agenda, and you feel that you would like to raise them now before we do move on? I don't want to close anybody down on. No, you covered that. I'll actually suggest, given it's nearly 11:15, we might actually take a short break at this point before we move on to item 2. So can I suggest that if we can come back for 11:25, please, and we'll start straight back on item 2. So for those of you who've been with us before, you know the protocol for breaks, but for anybody new, if you can stay on the call, you can turn your video off and mute your microphone, and then when we rejoin, you just turn them back on again. Okay, thank you very much.
You hear me all right on this? You there, Graham? Graham?
Hi.
I've just installed a new microphone. Can you hear me all right?
Yeah, it's perfectly clear.
It's okay. Thank you very much.
All right.
I've been struggling with those earphones for ages, and the internal microphone on the Mac is broken,
Right.
and it can't be fixed except at great expense because it means taking the whole face off and
Yeah.
fitting a new part. And Apple, my Mac is 8 or 9 years old, still working fine, but the microphone seems to have died. So
Certainly
I've just
it's loud and clear, so
Thank you, Graham. That's kind of you.
all right.
Take care. Bye.
Okay, welcome back everyone. It's 11:25. Just want to make sure everybody's back with us before I start asking questions.
Yes, thank you.
Mr. Hardy, Mr. Bell, and Mr. Robinson. See Mr. Bell, Mr. Hardy, Mr. Robinson. Who I can't see. There's Mr. Robinson, Mr. Hardy. Right, excellent. Okay, so we're moving on to item 2. So this is around the national planning policy context. Now, I don't intend to get. I don't want to go through all aspects of what, for example, what NPF3 and Scottish planning policy tells us. I know them fairly well, so I'm going to focus on the aspects where I think there are matters that I think are worth discussing in the context of this proposal. Now, under item 1, so Mr. Bell outlined his view that we didn't need to wait for express kind of shift in planning policy to give energy policy and targets greater weight in the planning balance. I think that's a relevant question or point to discuss in this part of the agenda. So I'm interested in that point in terms of whether or not that indicates that, is there any tension currently between the thrust of energy policy and where NPF3 and Scottish planning policy takes us in terms of that planning balance right now, or does that freedom exist already to essentially give whatever weight is appropriate based on the wider energy context? If I could ask the council first of all, if I could have your views on that point first, that would be helpful, please.
I think that's probably over to Mr. Robinson in the main, but if I just briefly start by saying that there's no indication that either the Scottish or the British government policy position with regard to the protection and support to the environment has changed in any of the policy documents that Mr. Bell or others have referred to. Central to these policy documents, and particularly in relation to consideration for development, is that development should be in the right place. And as far as the need arguments outweighing others, well, ultimately that's a matter for the decision maker to decide what weight to attach to each argument. But obviously, considering the issue of need, one must then consider the issue of alternatives and obviously site selection as well. And we've dealt with that earlier in the week. But then perhaps I'll pass over to Mr. Robinson after these brief introductions.
Yeah, okay, so effectively the question just to sum, is there any tension between energy policy and SPP and NPPF? In short, I don't think there is. I think there's enough scope set out in SPP to make decisions on wind energy proposals, taking everything into the round. That includes renewable energy benefits, socio-economic benefits, and indeed our own policy does in the local development plan, which we'll come on to later. So I won't mention that now. But obviously the criteria set out in paragraph 169 of SPP is quite varied. So I don't consider there's any tension at the moment. I don't think there's been any sort of shifting of balance as we've already alluded to before. So so that's my answer to that question.
Thank you, Mr. Robinson. If we can come to Mr. Campbell and Mr. Ford next, and then I'll hand over to Mr. Hardy and Mr. Bell. So, Mr. Campbell, Mr. Ford, I'll leave it to you to decide who responds to what aspect.
Will I go first? I agree with this basic point that essentially, I know Mr. Bell wishes to see it otherwise and trying to kind of panic us into this sense that we must get it all done now, which I have to say is a genuine sentiment, and I am very sympathetic to that. There is a dire need. However, in terms of the actual planning balance, particularly given the alternatives, you know, we still need to consider the landscape and the local issues, basically. So it does come back to this very unfortunate phrase about the right development in the right place. One of the things I'm signalling here is that because of the transmission issues, the right place is not necessarily Scotland for onshore wind energy. And I can go back to the numbers that I've cited in our submission about what the need is. And we know that essentially in Scotland, we have either built or consented and under building process nearly 13 gigawatts of onshore wind energy. We know that actually that is sufficient to meet the 50% target of whole energy demand by 2030, which is circa 11.5 gig, and obviously sets us on a good way towards meeting the whole target by, I forget when the Scottish Government final target is, 45, I think, something like that. So essentially, we are in a position where we actually are comfortable in terms of meeting electricity demand. I can happily go on to talk about transport and heat, but I have to say my observations on those two numbers, which are set out in my submission and come from the one of the Scottish Government papers, I can't remember which one off the top of my head, but essentially that whole energy picture, and that is that fundamentally in terms of home heating and so on, we aren't going to meet that by electrification, with all due respect. I mean, if we could convert all housing in Scotland to heat pumps, for example, the first thing is that actually that demand would fall by 75%, because essentially heat pumps have a coefficient of energy produced to energy input of 4, which means that the amount of electricity you put in, you get 4 times more heat out. But even accepting that, the housing stock in Scotland is not really suitable for heat pumps, and therefore we're going to have to find another solution. In transport, there's a figure.
Just sorry to interrupt you mid-flow. Just in terms of your point there about, so Scotland's not the right. Essentially, it's not the right. So the right place is not necessarily Scotland, I think your words were, in terms of wind energy, onshore wind. In that sense, is that, because obviously the right development in the right place is captured by Scottish planning policy, and then Scottish planning policy does give support in principle to onshore wind proposals. So is your position that in that sense, Scottish planning policy and national planning policy in Scotland has been left behind by, or has essentially the situation has overtaken itself, and there are different considerations that should be given greater weight?
I'm mindful of the fact that it's a reserved matter, and that essentially the Scottish government and Scottish planning policy can't actually deal with this issue about looking at the energy in a whole UK context, and the restraints that are on that, basically. I mean, we know from other decisions, I mean, there's the fairly famous Ineos fracking decision, where the Scottish government accepted that it can't make energy policy, and therefore used planning policy to achieve many of its energy objectives, if I can describe it as that, through planning policy. But essentially, I mean, we have a dilemma with the way that the Scottish planning policy works in Scotland, that essentially it looks at the planning perspective, but doesn't consider the whole energy perspective. And that's why, in a sense, we need to recognise that the regulator, the Ofgem and so on, are actually pointing to a different solution here. And we need to understand the limitations of the powers that we have in Scotland. So you know, the Scottish government can keep pushing at this as much as they want to. The fact of the matter is, this energy from this potential proposal isn't actually going anywhere.
Thank you, Mr. Ford. Mr. Campbell, do you have anything to add before I hand over to Mr. Bell and Mr. Hardy?
No, sir, I don't. Thank you.
Okay, thank you. Again, Mr. Bell or Mr. Hardy, I don't mind who starts or whether it's just one of you who speaks, but I'll hand over to you. Thank you.
Thanks, sir. A few points there. I'll try and take it fairly succinctly. I think, firstly, in terms of looking at planning policy and some of the other matters, this is an Electricity Act application, so that context is important. It's not under the TCPA, where we are dealing solely with the focus on SPP and the development plan as per Section 25. So there are wider matters in play, and certainly energy policy is something that the Scottish Government and ministers set out in their decision letters. I think in terms of NPF and SPP, we're all familiar with what they say. What I would focus on is that in terms of what it talks about, a move to a low carbon economy and society, you know, that was the world when it was drafted back in 2012, 2013. It's very different now, moving to net zero. And the targets and the legal references in NPF3 and to some extent SPP are out of date and have been overtaken. So they need to be viewed from that perspective. And turning to Mr. Armstrong spoke first. He was, if I heard him correctly, and Mr. Ford was suggesting this as well, that we need and you need to look at alternatives. And I would say that is not the correct approach, and that the development needs to be considered on its merits. There may be alternative layouts examined, but insofar as one may look at alternative sites or technologies and to place weight on the availability of alternatives in that context, I would suggest is wrong. but that will be picked up by my colleagues in terms of some legal submissions, I'm sure. In terms of what Mr. Robinson talked about in terms of SPP giving us a framework we can work with, I absolutely agree. I think the fundamentals in terms of the land use planning approach, the spatial framework has worked really well. And paragraph 169 gives us a steer on the considerations that come into play. What it doesn't do, of course, is give us the guidance on the matter of weight, and we explored that earlier. So, you know, putting that in context, what I would say is that whilst you could take the view that if this scheme was finally balanced in the past, I think you can take comfort as the decision maker before it goes to ministers, if you like, that there are these new considerations in play, which mean that this development is even more acceptable, and greater comfort can be taken from that. I think in terms of Mr. Ford's point about the capacity, there is about 8.4 gigawatts of operational capacity at the moment. There is consented capacity, and there's obviously some under construction as well. The Scottish Government's very aware of that, and they've made it clear in their programme for government that they're looking for an additional operational capacity of 8 to 12 gigawatts by 2030. And they've always taken the view that not every consented development will proceed to implementation for a variety of reasons, whether that's aviation radar constraints or whether it's the fact, and this is affecting many developments that were consented over the last few years at relatively low tip heights, which are simply not viable now. And there isn't a route for market for them. So we're seeing many applications coming forward that are seeking higher tip heights from, say, 125 meters, where they were consented at that level. I think the last point I would make has been touched on by Mr. Ford about well, the electricity cannot travel over the border. Well, there are major infrastructure projects underway. I'm involved in some of them, such as the HVDC link from that will go from Torness down to Hawthorne Pit in Yorkshire, which will enhance the wider transmission network. But that is not for this inquiry, I would say. We know SPP tells us very clearly that grid constraints are not material to individual decisions. And I can go to other decisions of the ministers that are before this inquiry that make that very clear. So we need to focus, I would say, on what are the material matters. SPP gives us a good guide, but for the reasons I've set out, it's helpful, but we need to look beyond it, and we're on the cusp of that further national planning policy change that we'll get an insight into in a few weeks.
Thank you, Mr. Bell. Mr. Hardy, then Mr. Ford. Thank you.
Yes, just very quickly. I'm not sure Mr. Ford answered your question with respect, which is whether there is a tension between the Energy Act provision or energy policy and Scottish planning policy. The answer is no, there isn't. They're doing two different things, of course, anyway, because if you're outside the Electricity Act, then the Scottish Planning Policy Framework gives you that decision-making framework for smaller schemes. But here, under the Electricity Act, you know the statutory criteria, you're taking into account all material considerations, the development plan and Scottish planning policy being two of those. And the fact that the Scottish land use policy is supportive and facilitative of wind chimes entirely with the fact that at a UK level, onshore wind is a key building block, and there will be sustained growth over the next decade. So to the extent that it dovetails, it's actually supportive. So no, there's no tension. Secondly, there was a point made, well, Scotland is not, I mean, I have to say it's quite an extraordinary thing to say to me. But Scotland's not the right place to put additional wind capacity. There isn't a shred of policy, guidance, legislation, or anything else that Mr. Ford can point to back that up. And I would say that should be treated with real caution. And thirdly, of course, grid connection really should be an end of it. Whatever concerns Mr. Ford has got about that really isn't a matter for you as the decision maker. This scheme has a grid connection, and that is all that's required. So 3 short points in response. Thank you.
Thank you, Mr. Hardy. Mr. Ford, I don't want to open it back up again fully, but in terms of the points that have been made by Mr. Bell and Mr. Hardy in particular, do you have any specific comments on those?
I've got 2, sir. I raised my hand about the point about the carbon and policy being out of date, and that was really the point I wanted to make first. And that is that essentially the need has not changed. The need, if you go back to the IPCC reports of the 2000s, the need for climate change has always been stated. It's never changed. What has happened over the last 10 years or so is that government has, if you like, started to turn the super tanker of activity, trying to turn it to adjust to the requirement. But so I think we ought to be careful about interpreting what the documents were saying, 8-10 years ago, kind of thing, simply because the need was always there. It's just that the government wasn't necessarily fully recognising, and it's very clear actually that you can see that government is churning away in its thinking, certainly at the UK level, about how to address the problem. And it doesn't just happen overnight. It does take many years, and you can see a strategy in terms of addressing the low-hanging fruit, essentially, of the electricity power system, and then moving on to transport and home heating. So I think we just got to be careful there. The second point goes to this point about grid connection, which Mr. Hardy and Mr. Bell have just raised. I'm happy to talk about that. I think we should talk about it at some point. I have to say I do disagree with them, and I'd like to set out a case for why I disagree with them. If not now, then certainly in closing submissions. But it might be useful just to debate it now, so that the applicant has an opportunity to respond.
What I would say is let's touch upon that again under item 4. I don't think I need a particularly long discussion about that, but if there are specific points that you wish to raise during the hearing, then item 4 would be the place for that. Okay, Mr. Ford, so I'll give you the chance to do that there. Okay. So staying under item 2. Sorry, did somebody speak there? No, okay, that's fine. I thought I heard somebody somebody tried to get my attention. So if I can turn to in the context of national planning policy, and appreciating, this is an Electricity Act case, we have the statutory purpose of planning established by the Planning Scotland Act 2019, so that amended the 97 Planning Act. And this states that the purpose of planning is to manage the development and use of land in the long-term public interest. And my question is, I'd like your views on what long-term means in this context. So, for example, is the 40-year consent being sought long-term, or is it a different picture to that? So that's my initial question on that point. So I'm interested in exploring, can there or are there differences between what may be in the long-term public interest versus the short-term public interest? If anybody needs a reference for the Planning Scotland Act, it's CD 1407. Although I don't think we need to look at it. I don't mind who speaks first, so it's whoever indicates first, I think. Mr. Bell, thank you.
Thank you, sir. Sorry, I just dived in there. I think I'm maybe the only planning witness that's referred to the statutory purpose of planning in my hearing statement, which is now, I believe, in force, and it will be for NPF 4 to address that. And under the Act, it refers to outcomes of planning, and one is meeting any targets relating to the reduction of emissions of greenhouse gases. And we know, and we'll come on to that perhaps just shortly, about NPF 4, that is that's a key underpinning principle and policy in NPF 4. It will be about net zero, because it's a plan for Scotland in 2050. That is the title in NPF 4, page 4, and it looks at outcomes for 2050. And one of the outcomes, it says the NPF4 will focus on achieving is net zero emissions. And that is exactly chiming with the reference in the 97 Act as amended. So I would say that long term is not just 40 years, it is beyond that. It's to be well beyond 2050, because it's ensuring that the electrification that we are moving to is sustainable beyond then. Because clearly getting to 2050 isn't the end of the matter. It needs to be sustainable energy that is continued on. And that clearly perhaps require, whether it's repowering or a new consent, but that would be for another day and place. But the statutory purpose of planning, I thought, was important to tie in as part of the statutory framework that we're dealing with policy following that and catching up again through NPF4.
Thank you, Mr. Bell. And are there any responses to what Mr. Bell said there, or to my question that I posed? Mr. Robinson?
I think I could just add, yes, I would agree with Mr. Bell. I would say 40 years is a long term. I suppose as well, looking at paragraph 28 of SPP, the planning system should support, it has a reference to balancing the costs and benefits of a proposal over the longer term. So I think that's already set out in current policy, and obviously the legislation is reaffirming that. But I would say that a proposal of 40 years would be in the long term. I've seen some decisions on wind farm proposals sort of considering whether 40 years is within somebody's generation of lifetime, and it's been concluded or considered that 40 years would be within take up a generation of somebody's lifetime. So I would suggest that 40-year consent that's been proposed is a long-term proposal.
And I think so. On that point, Mr. Bell kind of said, "Well, actually, 40 years isn't the that isn't the kind of cut off as such. That's almost the start." I think was Mr. Bell's point on that. So I just want to check whether you are in agreement or not. I'm just like, I don't want to misunderstand what's being said. So in terms of Mr. Bell, just ask you to just comment on that point. I'll give Mr. Robinson a chance to respond. Sorry, Mr. Bell. Sorry, please.
Sorry, I didn't mean to interrupt. No. Just say I think there is a disagreement there. I think long term goes beyond 40 years, and that's clear in a number of the energy documents that are before the inquiry. Is that the issue of climate change doesn't stop at 2050. It has to be sustained and beyond that date.
Mr. Robinson, did you want to respond to that at all?
I mean, if I'm thinking that a 40-year consent is long term, then clearly anything beyond that would also be long term as well. So, and the longer term, 40 plus years. So, yeah, I'd agree with that. Okay,
that's helpful. Thanks. So, Mr. Ford, please. I think I saw your hand first, or Mr. Campbell. Again, you can decide between you.
You go first, Mr. Campbell.
You go first, please.
I'm going to basically agree here. Somewhere in one of the documents, and I can't remember what it is off the top of my head, there is also a sentiment that when we're giving these long period consents, whether they're 20, 30, 40 years, we should also be mindful of the fact that these are effectively permanent sites. The timing of these consents is a way of adding some additional control so that over many decades ahead, there is an ability to reconsider them basically. But essentially, I think we should be looking at this as being a potentially permanent site for wind energy. And I think it should be really considered in that context. So in that sense, long term means I don't think there's much disagreement here.
Mr. Campbell, please.
My point was a short one. Reading the whole of the section which deals with the purpose of planning, It's not just about long-term development, it's about long-term development in the public interest. Nobody would sensibly argue that combating climate change is not in the public interest. But the question for you is whether this development will or may be effective in achieving that objective. Part of the equation is whether this electricity can be used, which brings us back to transmission questions, which you said we'll deal with later. So remember, when you're looking at the purpose of planning, as David Bell has pointed out, he's the only one I think who's highlighted the section. You have to read the whole section and not just the bit that deals with long-term development. I can agree for what it's worth that 40 years is long-term, and axiomatically longer than 40 years is still long-term. Must be. SNH, or to give them their new name, Nature Scott, I think advise in their landscape guidance that sites should be looked at as permanent locations for wind turbine generation. I can't quote the section at the moment, but that is certainly looking at it from a slightly different perspective. Shouldn't be an issue that 40 years is long term. Thank you.
Thank you, Mr. Campbell. So I'm going to go to Mr. Ferguson first, Mr. Robinson, and then Mr. Hardy. Thank you.
Yes, thank you, sir. It's subparagraph 3 of 3ZA, which you refer to. And if I'm following this correctly, this section and the purpose of planning only relates to development planning as opposed to development control activity. It only relates to parts 1A and part 2 of the Act. So while it does have a role to play in the wider sense, I don't believe that it has a direct role to play in the decision of the ministers in this case.
Thank you, Mr. Ferguson. Mr. Robinson.
Sorry.
Sorry, Mr. Bell. I'll come back to you. I'm going to go to Mr. Robinson first. Okay, thank you.
I think I just wanted to add on to the point and refer to paragraph 170 of SPP, which I haven't got the core document number to hand, sorry.
Oh, that's okay.
But yeah, paragraph 170 on page 41, areas identified for wind farms should be suitable for use in perpetuity. Consents may be time limited, but wind farms should nevertheless be sited and designed to ensure impacts are minimised and to protect an acceptable level of amenity for adjacent communities. So I just wanted to refer to that paragraph in SPP, just given the way that the conversation was going.
Thank you. Mr. Hardy and Mr. Bell.
Yes, I made a number of points. I think longer term being used in a number of different ways. Firstly, I think if you're assessing impacts, and this really picks up on the point that's just been made by Mr. Robinson, in terms of assessing impacts, then you don't dilute those somehow on the basis of reversibility. So you treat the impacts as if the scheme were permanent, but reversibility, the fact that this is time limited and it's a time limited consent, is a material consideration in terms of the longer term custodianship of the landscape. So in that sense, yes, long term, yes, you in terms of your impact analysis, but when you're looking in the longer term objectives of planning, which I think was where the question started, then that goes beyond that, and the fact that the reversibility and the development can be taken away then becomes important. And I think I mean, we can agree in terms of the whether it's a development management point or a forward planning point, that's correct technically, but the putting the it's like an interest-bearing account, isn't it? That what you're trying to do is get the money now and compound interest over time. That's the thing that matters. So helping with climate change and helping with decarbonisation now is pennies in the bank. And then as you move on, compound interest, the more of those schemes which are with their accretive effects, then in the longer term you reap the benefit of them. So it's decisions which are made now, which will then be of benefit in the longer term, beyond the 40 years or 50 years or the 100 years indeed.
Thanks, Mr. Hardy. Mr. Bell.
Yes, thank you. I was just going to say that Mr. Ferguson's absolutely right. That is, it's not a specific development management point, but in my hearing statement at 345, what I say after my reference to the statutory purpose is that it's clear that the public interest will be key and underpin the preparation of NPF4, which is that development planning point that Mr. Ferguson has raised. So it's for NPF4 that we'll be dealing with that. And it further underlines the point of planning policy having to catch up with the law. So not just the Emissions Reduction Act, but also the statutory purpose of planning, which isn't reflected in NPF 3 or SPP at the moment. But we will see that in a few weeks in NPF 4 draft.
Thank you, Mr. Bell. That might be a neat link to touch upon NPF 4. Now, obviously, we don't have NPF 4 published yet, so or the draft NPF 4, so we're not going to have a debate about that. We have got the position statement. We need to be mindful of how that position statement was described. So it was a discussion paper, essentially. So it's not policy. But I think it's important that we have the opportunity to say anything that we think is relevant at this stage that can be taken from that document in that context. So there are kind of health warnings that come with it. But I'd still like to hear your views on what intent that indicates. Mr. Bell, would you like to start on that?
Thank you. Yes, I think in terms of what the document is, you're right. It's not formal planning policy. It's clear in that, but it does say that it gives an insight into the direction of travel of where the government is going. And we saw a bit more of that in the programme for government, in the Butte Agreement, and then the programme for government, where some of these points were articulated with a bit more specification, such as the onshore wind target to be consulted on. I think for me, the key point would be the outcomes for 2050, net zero emissions. As I said earlier, that's fundamental to NPF4 and delivering that. And the government says that to help do that, they will rebalance the planning system so that climate change is a guiding principle for all plans and decisions. Page 6 talks about actively facilitating decarbonised electricity generation. And we also know that it will be part of the development plan, statutory development plan. So as would be normal when we are dealing with a development plan document that is dated 2014 and we get a new draft, albeit still to be consulted upon, it will be gathering weight. It will be appropriate to afford it some weight depending on what it says in relation to what is out of date then in the 2014 element of the plan. Now, in this case, SPP at the moment is not part of the development plan dated 2014, but the LDP for Dumfries and Galloway is. So we'll be in a situation where we've got an emerging element of the development plan and draft that's very up to date, and we will have an older element of the development plan, which is the LDP. We'll maybe come on to that later in the agenda. But what we do know is that NPF4 will be reflecting climate emergency, new emissions law, and the net zero policy imperative. It also refers to onshore wind. So again, just picking up on some of the points that Mr. Ford was saying, I think you would need, sir, to look at what NPF4 says on onshore wind. I think one other point is that in terms of the climate emergency, I've heard this before, that it's not a material consideration at the moment, and that's only being considered through NPF4. I don't think that's right. I think when you look at the wording, it states that the NPF4 will confirm the government's view that the climate emergency is a material consideration. So I would say it already is, and we will see how that plays out in a few weeks. Thank you.
Thank you, Mr. Bell. Mr. Campbell, please.
I don't think Mr. Bell is suggesting that we reconvene this inquiry to consider NPF4 when it is published. But if he is, then it would be good to know that. The former chief planner was, that's the first point. The second point is former chief planner, Mr. McNerney, gave a seminar on his position paper, which I was privileged to attend, and without necessarily wishing to give evidence, he was very clear that it was a position paper. I accept, of course, that it indicates the direction of travel, but he was also very clear that nothing in it should be relied on as an articulation of finalised policy. So it carries weight. Of course, I agree that. But it doesn't carry much weight because it is just a government thinking paper at the present time.
Thank you, Mr. Campbell. I set that caveat in my
did.
question. In terms of just on that point, rather than ask Mr. Bell to respond to how we should treat the NPF4 draft when it arrives, because it is imminent. There's a high likelihood, if not certainty, that the draft will be published before my report is complete. In that case, the likelihood is that I will ask for further written submissions on that specific document, given it will be of some significance. But my intention would not be to reopen the inquiry. I saw a couple of hands, but I did. I'll go to Mr. Ford first, because I follows on from Mr. Campbell, and then I'll come to you, Mr. Hardy.
It was just on that procedural point. It wasn't anything substantive. So I don't know.
Okay, no. Yeah,
very quickly, yes, to say we've discussed it. Of course, there's also the onshore wind position statement, and instruction is that's coming out next week. I think we would be hopeful that could be dealt with by way of written submissions. But I would just want to reserve the right to put in an application for a further session, depending on what they say, because at the moment I don't really know. Hope that it's going to be able to be dealt with in writing, but if it is so central to the decision making here, then I want to just leave open that hook to come back and say we might need another morning session. So in writing preferably, but with liberty to apply.
That's noted, Mr. Hardy. Thank you. My view is that I think we should be able to deal with it under written submissions, but the door's not slammed shut. So thank you. Mr. Ford, please.
Thank you, sir. Just in terms of NPF4, three things to quickly highlight. First of all, that the NPF4 statement actually does reiterate this consideration of local environmental effects, and that's not washed away in any sense at all. That's restated. Secondly, there's quite a strong emphasis on repowering and the potential meeting of demand through repowering. And thirdly, there is a reference there to the export of energy. So it is something that is within the scope of this inquiry, this whole issue about transmission and so on. So thanks very much. That was all.
Thank you. Mr. Robinson, please.
I think just adding my opinion into this debate. I've put this in section 510 of my hearing statement. But in particular 5.10.2, I've tried to focus on the element of the position statement which refers to onshore wind, and effectively it makes note and makes reference that they will be allowed where they are demonstrated to be acceptable on the basis of site-specific assessment. So that seems to be considered in line with the current policy approach at the minute, but obviously we'll have to wait and see what the draft version states when it is published.
Thank you, Mr. Robinson. Are there any other points under item 2 that people would wish to make before I move on? Okay.
Can I just make one very small point, sir, which is just to flag something up later on. Use the term predicted electrical output. That's something that I think we should be discussing under point 4.
So could you repeat that, Mr. Ford? I didn't quite catch what you said.
And under your agenda, you use the phrase predicted electrical output of the wind farm or of a wind farm. I just want to flag up that I think that is something we should be discussing under point 4 later on in the agenda.
I've got a note of it. Thank you. Yeah. Okay, so item 3, the development plan. Now, again, comes with the caveat. Obviously, this is not there's not a Section 25 test to apply to this proposal, and there's no dispute over that point either. So Dumfries and Galloway Council have said that the application, obviously, because it will involve deemed planning permission as well if it's consented, the development plan should be given full weight. And I wanted to ask first of all ask the council to clarify what it meant by full weight in this context. So, Mr. Armstrong or Mr. Ferguson or Mr. Robinson.
Perhaps if I start, I mean, full weight is that the council are respectfully suggesting to you and the Scottish ministers that it should be given considerable weight, because clearly it is the most relevant local policy document for consideration of this proposal. It is up to date. It has recently been gone through the planning process, and it has policies and consideration that directly are relevant to this proposal. And with that introduction, if I could just hand over to Mr. Robinson.
Yes, basically our view is it's entitled to full weight. It really is a key document in actually getting to assess the suitability of this development and acceptability. So obviously the development plan policy, IN2, and particularly its associated supplementary guidance, which includes the landscape capacity study, which are obviously documents where judgments can start to be formed on the acceptability of the development, considering alongside obviously the site-specific assessments that's been carried out as part of the development proposal. So that's why we consider the development plan is considered to be full weight. In essence, it's the main thing really. We consider where you could start to actually consider the suitability and acceptability of the development in a meaningful way.
Thank you. Mr. Bell, please, or Mr. Hardy. Yeah.
Yeah, I mean, hearing that, of course, with the caveat, it's not TCPA case, but that's subject to giving full weight to those parts of the plan which are consistent with policy and guidance. So we take issue with the point about it being fully up to date, and that's based on the observations and discussions on the capacity study about which you know. So in short, it's common ground that the underlying character assessment as 1995, 98, you know, that pre the 2002 guidance, some updating into the capacity study, but then the point being that we say is out of date with SNH's position. That may be one of those documents that falls into that category of likely to drop imminently. I think you've seen that Nature Scott said that they believe the sensitivity study guidance was going to be late. I think it said late autumn 2021. Well, I don't know what late autumn means. I mean, we're in mid-autumn, I would say. So I suspect certainly in the currency of decision making, that will drop. That will crystallize that point about that capacity study being out of date, and our submission would need to be that it would need to be revisited. So don't accept full weight, but it's based on the evidence that you've heard.
Thank you. Mr. Robinson.
Yeah, I mean, obviously that was point was put to Mr. Steele in his cross-examination. I think it's important to refer to the executive summary of the Dumfries and Galloway landscape capacity study, which acknowledges that it was revised and updated. And I think it's also worth clarifying that the 1995 or published in 1998 landscape character assessment has actually been superseded. It's been superseded by Nature Scott's 2019 landscape character types. And the key thing here is whether the landscape capacity study aligns with the landscape character areas identified in those. And there hasn't really been that much in terms of an update, in particularly the 2019 landscape character type designations generally align with the capacity study, but the capacity study is being written in a wind farm context, whereas the landscape character type is more general and generic in its terms. And actually the Nature Scott website, on its page regarding the new landscape character assessments, which came into force in 2019, it actually states where there are topic-specific landscape capacity or sensitivity studies, they would take precedence for informing that development type, e.g. wind farms. So we don't agree that the capacity study is out of date as a result. It's actually taken into account a change in emphasis of the way that wind farm developments are going. And that's actually stated in the executive summary, which actually says it was revised and updated in response to the considerable amount of wind farm development in Dumfries and Galloway. So I do feel that it has been updated, responding to the way that the wind energy industry is moving. Again, taking that into account what the actual sensitivity of the landscapes are.
So I'm sure you've got the point. That's rather missing my submission. As you know, it's about the whether it is in alignment with what SNA, what Nature Scott are saying in terms of the difference between capacity and sensitivity. So there are some points to make about the agedness of the character appraisal, but that's not the principal point, as you know. It's the fact that the capacity study contains the offensive parts of levels and thresholds, which it shouldn't do. So I know you've got that point.
Yeah, I don't want to go over the same ground on that point. Obviously, we've heard that in inquiry session 2. But yeah, I understand the point you're making as well, Mr. Robinson, there. Mr. Campbell or Mr. Ford, do you have any comments on that particular point? Mr. Ford?
Just a couple of quick comments, really. And that is that I'm not really here to defend the local development plan, but I have looked at it, not actually very recently, certainly I think in the last year or so. And as far as I'm concerned, and I look across all of Scotland, in fact, all across Great Britain, in fact, in terms of these plans, as far as my reading of it is, it's a pretty strong set of documentation. And the local authority have done their work here. And in terms of reading their assessment and their report on this proposal, I think they've done their job, and I would certainly, from a professional point of view here, kind of confirm that I'm perfectly happy with that. The second point is just, again, looking at this broader picture. I look at, as I say, the whole Scotland and the whole of Great Britain. I'm aware that, in fact, Dumfries and Galloway is probably the authority in the whole of the country, not just Scotland, but in Great Britain, facing more onshore wind development applications than any authority in the country. And therefore, we ought to be mindful when we're talking about whether certain aspects of it are up to date or not up to date kind of thing. We ought to be mindful of the resourcing issue here. Planning authorities, in fact, less so in Scotland than in England, but planning authorities are generally under-resourced at the moment. So I think it's a bit hard to be applying, very tight judgments about whether some dot or comma is full up to date or so. I think we should be respecting here that the planning authority has done a good job, and that it is actually under-resourced given the volume of applications that are coming forward. There are other ways in which that can be done, but essentially we should recognise that resourcing issue. The local authority here is under a lot of pressure to get coherent reports out, and they're certainly doing that as far as I can see.
Right, that's noted. Yeah, I mean the development plan is what it is, and things change as well. So there are, it has to be taken on the basis in which it's adopted. But Mr. Bell, I saw your hand, I think.
Thank you. Just a brief point. I mean, that resourcing issue, yes, as a planner, I sympathise with that, but that's a matter of the management performance of Dumfries and Galloway Council, and it's not for this inquiry to sort that issue out. I think what the development activity also demonstrates is that the wind resource in Dumfries and Galloway, the Group 3 coverage, and the grid availability. So it's a reflection of that. That is why the private sector has reacted with the development activity that it has. That is simply a reflection of that.
Moving on to specifics in terms of the local development plan, I'd like to just touch upon which policies are of most relevance in terms of applying them to my assessment. So obviously the council have identified five main policies. So my question is, do policies IN1, so that's renewable energy, and that's on page 67, and IN2, which follows it, that's wind energy on page 69. Do they effectively cover the same issues as policies OP1, development considerations, and OP2, which is design quality and placemaking? Do they cover the same points in terms that are more sort of tailored to assessing wind farm proposals? I suppose to rephrase that question, do Iron 2 and or Iron 1 add anything to the assessment? I'm going to ask the council first for its view. Now, I appreciate you've applied those policies, so I'm expecting a particular answer, but I'll hand over to you.
Yes, policies IN1, particularly policy IN2, is the main policy in respect of wind energy, and obviously NE2 because of the close proximity to the regional scenic area in this case. So of course, that's also a relevant, is a key policy as well, because that's where
we'll come back to that, I think. Yes, thank you. Yes, sorry, I should have said.
In terms of OP1 and OP2, there's obviously other considerations in this as well. Obviously, in terms of residential amenity, for example, I think OP1A is quite important in that regard. Should not conflict with nearby land uses. And so that again is taking into account the sort of considerations in more details that, for example, need to be considered when we are assessing impacts on the residential amenity of nearby land uses. In this case, that would be residential properties. They are overview policies of the plan, but they have to be read in conjunction with IN2. So it's our and they're setting the overarching aims. Again, OP2 in terms of design quality. I appreciate some reporters have considered it, and some haven't. So there has been a sort of difference of opinion in terms of the huge relevance. But again, it's the key point in the first paragraph of that policy, basically, that development proposals should achieve high quality designs in terms of their contribution to the existing built and natural environment. So it is relevant in that context. But obviously, in terms of getting to the detailed assessment of the proposal, it is IN2 that is the main policy in this respect, and the associated supplementary guidance.
Thank you, Mr. Robinson. That's helpful. Mr. Bell or Mr. Hardy, do you have any comment on that?
Yes, I don't think we're too far apart on that. I've set out in my hearing statement on page 26 how these policies have been referred to in other decisions, and we heard earlier the importance of consistency in decision making and reasoning, and I would say that the approach set out in these other decisions is sensible, on a fair reading of what the policies say, and even policy OP1A, nearby land uses, yes, that is relevant, but in IN2 we get a specific reference to residential interests, so that is captured by it, and I think a reading of those policies, in terms of their content, they're very relevant to more standard urban built development. The lead policy is IN2, that's the dominant policy supported by IN1. So I don't think we're far apart, but I would say, the focus should be on IN2.
Thank you, Mr. Bell. Does anybody have anything to add to that particular point?
I have nothing to add, sir.
Thank you. Okay. If we can turn to policy ED11, dark skies. Just bear with me a second, because I have a lot of documents open and I want to make sure I have it in front of me. The dark skies policy is on page 31. Sorry, just bear with me because my computer's just started to. Can you see me okay? Yeah, it's not. Yeah, okay. It's just my
yes,
my computer being a bit slow. Just bear with me a second because I want it in front of me here. Sorry, wasn't responding, but it is now responding, I think. Right, there we go. So in terms of the dark skies policy, my question is: does this raise the policy bar in this location when considering the effects of visible aviation warning lighting, kind of over and above the consideration of the visual impact of lighting more widely? So I suppose what's the policy and practical implications of being in the dark skies park transition zone? So again, I think I'll come to the council first, please. By all means, take a moment to gather your thoughts.
Yes, I'm just loading up the supplementary guidance actually, that needs to be read alongside this policy.
Okay, yeah.
It's really referring to, I mean, Part A of policy ED11 is referring to the Galloway Forest dark sky. Obviously, it's not, this proposal's not within that, but it's bordering the transition zone. And really, I think I would refer you to Appendix 2 of the supplementary guidance on, let me just get the title of it, Dark Skies Friendly Lighting, which sets detailed considerations for new and replacement lighting. And in terms of wind farm development, page 13, in the transition zone, it does say preferable for maximum of infrared lights to be used. So this is in that area. So that is where the supplementary guidance is really steering proposals to. So if we're getting proposals that aren't for infrared lighting, then there is a potential conflict with the policy there, and it needs to be looked at through detailed consideration. It doesn't mean to say that non-infrared lighting will be unacceptable, but there has to be a clear consideration given to the impacts of red lighting, particularly what is a dark, the inherent character of the area where this proposal is it is in a dark area. And I think it was the Mr. Campbell's witness who lives in Shingle Head gave some evidence on that yesterday in more detail.
Yeah. Thanks, Mr. Robinson. Yes, I was looking at the supplementary guidance and the table which you referred to. Obviously, the first two columns have a more absolute statement of maximum of infrared lights, and then into the transition it says preferable. So that's essentially that site-specific case-by-case judgment that needs to be made in these circumstances. Right. Mr. Bell or Mr. Hardy, and actually no, Mr. Campbell first, please. I can see your hand there.
Just to make a very short point and ask ourselves rhetorically what the point of this policy is. It's not, I would respectfully suggest, not simply to preserve darkness, but it has both an intellectual content and also a visitor or tourism content. Intellectual because the study of astronomy for its own sake is a recognized discipline. Tourism because, as Miss Mooney said yesterday, it is a feature of this area which attracts people. You will probably know that the observatory at Craig and Gillen next to Dalmellington unfortunately burnt to the ground about 6 weeks ago. And so the area is deprived of that resource until it can be replaced. And Miss Mooney was not saying that she has a telescope. She's simply articulating her aspirations. So I just make that point in relation to the purpose of the policy, or the perceived purpose of the policy.
Thanks, Mr. Campbell. Yeah, that's helpful. Mr. Bell or Mr. Hardy, please.
Well, very little to add. You're right. It's a case-specific, site-specific, case-by-case analysis because we are on the edge of the transition zone. And just refer you to Mr. Denny's evidence or an introduction of no significant effects to areas where there aren't significant effects otherwise. In terms of that point about observatories, I mean, interesting, but aspirations about having a telescope and so at Shingle Head really can't be given very much weight. So I can just keep it short. It's no bar, and Mr. Denny deals with it.
Thanks, Mr. Hardy. Are there any other points on ED11 and the supplementary guidance that accompanies that policy? No. Okay. So then turning to policy NE2, This is the regional scenic areas policy. I want to kind of understand what the policy test is, or what the correct policy test should be for considering developments which affect a regional scenic area. So there's no dispute that this development wouldn't be within the regional scenic area. And we've heard Mr. Denny's evidence that the integrity of the area as a whole would not be affected or undermined by the wind farm. And my question, which I did pose to Mr. Steele and asked for his views, and I said I was going to ask it today, was, does that answer the right question? Is my main point. So I'm going to come to the council first, please.
Yes, well, sir, perhaps if I open up on this, as we already discussed with Mr. Denny, his analysis doesn't answer the right question, and that there is no assessment of the right question by the applicants in this case. The right question is set by the criteria in bullet point 1 of NE2. The factors taken into account in designating the area would not be significantly adversely affected, and we've heard the evidence of Mr. Steele and the written evidence from the council's landscape architect in relation to that point. If I now hand over to Mr. Robinson on that.
I think I'll just start by sort of giving some background to the policy. Effectively, the thrust of the policy and its reason for inclusion is based on paragraphs 196 and 197 of SPP, which provides support for the designation of areas of local landscape value, and the SPP indicates that the purpose is to safeguard and enhance the character and quality of locally or regional valued landscape character, and obviously the Thornhill Regional Scenic Area has been designated as such. So SPP effectively states that locally designated areas should be identified and afford an appropriate level of protection in development plans. So NE2 is consistent with that requirement. To support the policy, it's key to refer to the technical paper, which in my view highlights what the factors are in terms of the regional scenic area. I'm just loading this document now, and to me, to really consider the proposal, or any proposal against this policy, you really need to look at what the key features, the key factors are in the area. And I think paragraph 33 in this case, it was, I think Mr. Denny was shown to these by Mr. Armstrong. It's really looking at what these key factors are that's listed on this page, and whether there's anything there that a proposal would significantly adversely affect. And I would go and refer to the committee report, which I think gives a very detailed analysis of this in paragraphs 483 to paragraph 4.89, and it identifies what are considered to be the most relevant factors, and then has taken that into account in really looking at the detail of how this proposal adverse affects these factors that have been taken into account. So that is the thrust of the policy. If you want me to add any more to that, please let me know.
Thanks, Mr. Robertson. I'd ask for your view in terms of whether or not the integrity question, so that's one which appears in SPP paragraph 212 in terms of national designations. Is that a more challenging question, or is that easier to meet, given it applies to a national designation rather than a regional or local?
The policy NE2 doesn't refer to integrity. So that is in policy NE1, which is the policy referring to national scenic areas, and there is I would say a stronger wording in policy NE1 referring to national scenic areas. So we're on page 51 of the local development plan 2, and obviously that refers to the term integrity of the area, whereas in regional scenic areas the policy refers to the factors taken into account would not be significantly adversely affected. So that's the key test here is will these factors be significantly adversely affected? So I do think there is a difference in the way the policies are to be approached. I would say that the way the policies are set up is correct in that it's giving the national scenic area there's more strength in that policy in terms of assessing those because they are a national designation. But policy NE2 is in line with paragraphs 196 and 197 of SPP effectively.
Thank you. Mr. Bell, Mr. Hardy.
Well, I'll start. I mean, the higher bar point you've got, of course, there shouldn't be a higher bar. This is RSA, so that I don't need to take any more time on. It really goes back to the evidence of Mr. Denny, and that the technical paper doesn't set out a definitive list of special qualities, nor does it give a clear indication of the reasoning behind the original designation of the RSA. And what the council says, well, if you look at page 33, then you have a list, and it would be obvious to anybody. Well, that with respect isn't good enough. But what Mr. Denny did do, of course, is focus upon effects upon landscape character and visual amenity, and within the RSA, and then views outside the RSA, of which that would be a component. And that was done by reference to those descriptors set out on page 33 anyway. So, I mean, just to finish, I think you heard the point made by Mr. Denny. Said, well, it would have saved 15 minutes of cross-examination had they been listed as, as reasons underlying original designation or indeed special qualities. The point is, substantively, there has been an assessment by Mr. Denny of those descriptors in terms of character and visual amenity. Therefore, you've got the information before you. So I think let's look at substance rather than form.
I would just add. So,
Mr. Bell, yes, please.
My apologies for jumping in there. I would just add to that of course, it's a local designation we're dealing with. I'm not seeking to say it's not important, but it doesn't feature as a constraint in the spatial framework approach to wind energy. It's effectively group 3, in which wind farms are likely to be acceptable, subject to considerations. And there are numerous developments of wind farms within local designations. This development is not within that. So I think in terms of looking at the policy expression differences, the high national bar test is in NE1, and that should not be borrowed or imported into looking at a group 3 local designation.
Yeah, I should just probably clarify why I mentioned that in that context. It's because obviously Mr. Denny does apply the integrity question to his evidence, and my question was, well, if it meets that test as argued by Mr. Denny, does that automatically therefore mean that it must satisfy any tests that would apply to a regional or local designation in that context?
It would do, and I've set out in my hearing statement the specific reasoning that Mr. Denny draws upon for that as in his evidence. Yes,
I think that's a yes. If I may, I think that's a yes. But even if the wording is slightly different, if the point is said, oh well, it doesn't automatically follow that a different test would also be satisfied. You've got the substance of the assessment, which is based on character and on visual amenity anyway. So yes, but even if you don't accept that, then you've got the information anyway.
I understand. Mr. Armstrong.
But sorry, it's just to come back on that. It is a very different test, and as has just been set out, if one looks at page 51, one can see that there is a different policy wording in relation to NE1 and NE2, and the test in NE2 is clear. And the problem for the applicant is obviously Mr. Denny says it's up to Mr. Bell to consider this test, and Mr. Bell says he relies on Mr. Denny, and Mr. Denny has looked at the integrity test, not looked at the factors taken into account in the designation of the area and whether they'd be a significant adverse, whether they'd be significantly adversely affected. The basis for that test is obviously set out in technical paper 6, and we did go through that with Mr. Denny and the introduction to that technical paper. But the difficulty is that one suspects that because that there are considerable difficulties for the applicant, that the applicant has turned a blind eye to the appropriate test and has looked at a different test. And the council in it, and the council in its evidence has analysed the correct test and set out its position on that correct test.
Thank you, Mr. Armstrong. Sorry, I had my head down writing then, so I don't know if anybody indicated that they wanted to follow up or make any comments. Mr. Campbell.
Just to say we don't agree with any of that, but that comes as no surprise. I'll stick with what I've said before. Yeah.
No, that's fine. I understand the disagreement. Yes, thank you. It's noted. Mr. Campbell.
Well, just we rely on the council and agree with them in respect of the interpretation of this part of the policy.
Can I also just add that somebody that travels in many parts of Scotland, this is a very scenic area. And actually, I think this is an interesting question as to whether or not it would actually is worthy of actually uprating to a national scenic area.
I won't be bringing that one into play right now, Mr. Ford. I think that goes beyond my my role in this inquiry.
But it is a very attractive area.
Thank you, Mr. Ford. Thank you, Mr. Campbell. Okay. Something that we haven't really touched upon much at all, and perhaps we don't need to, but I just want to give you the opportunity to, if it's appropriate, is to consider whether there are any aspects of the East Ayrshire LDP which anyone would like to bring to my attention in terms of, are there any sort of notable differences in particular which I should be aware of in considering this proposal? I'm not seeing you falling over yourselves to answer that one, so I'll take that as the answer. I can make of that myself what I need to myself. That's fine. Okay. Now, in terms of my questions around the wind supplementary guidance, obviously the Dumfries and Galloway supplementary guidance, to be honest, actually, I think I probably had answers to nearly all of my questions on that during the course of the inquiry. So obviously, I need to form my own view on it. Mr. Robinson, is there anything that you would like me to particularly focus on in terms of the wind energy supplementary guidance, which you think might not have been brought to my attention already?
Yes, I've referred to relevant sections in the inquiry report I think are important to refer to. In particularly, they're set out in landscape and visual impact terms. They are sections C and D, and I've listed those paragraph numbers in particular. And we would certainly like to refer you to paragraph D11, which sets the criteria for cumulative impacts of pattern of development. And that's obviously a very important consideration in this proposal, particularly with the evidence we've heard regarding the scale and extent of this proposal in comparison to the existing operational and consented developments in that locality. And again, the criteria and considerations to be tested, particularly we heard the term coalescence between existing consented developments. That's all set out in paragraph D11. Again, the last bullet point is quite important. Maintain the visual distinction between areas where wind farms are a key characteristic or on occasion a defining characteristic wind farm landscape, and areas out with them where wind farms occur as isolated features or not at all. And that was actually a consideration in the recent Corn-Harrow decision. The core document number don't have to hand.
That's okay.
It's a scheme that's not very far away from this site, and in terms of wind farm patterns, some of the viewpoints that were considered in that scheme were identical to this scheme, particularly Ben Bracken. The subject of wind farm pattern was considered by the reporter in that appeal decision.
Thank you, Mr. Robinson.
So just for completeness, obviously dealing with your third bullet point in 3 paragraphs C1 to C3 of the supplementary guidance on page 9 and page 10 sort of tie in the connection with the DGWLCS, and obviously C3 identifies that potential wind energy developments will be required to demonstrate how they have taken account of and responded to the assessments and guidance in the DGWLCS and any specific landscape and visual issues associated with the site.
Thank you, Mr. Armstrong. Mr. Bell, do you have any comments to make on that?
Just a couple of brief points. I think clearly the supplementary guidance structure is below the parent policy IN2, so that it's helpful that the structure of it follows that. But we go back to the policy tests in IN2 overall. And I think that's the only point I would make on that.
Yeah, thank you. Can I check, Mr. Campbell or Mr. Ford, do you have anything to add on that point? No. Okay, thank you. Okay, I don't have any further questions that I want to ask about the development plan. So are there any aspects at all which anybody would wish to raise and haven't had the opportunity to do so? No. Okay. I would suggest, and rather than us move on to item 4, that might be an opportune moment to break for lunch. 12:45. So if we have an hour's break and return at 1:45, please. As before, please don't leave the call. Just turn your video off and mute your microphone. And I'll see you then for the final part of the agenda. Okay. Thank you very much so far.
Thank you, sir. Yes, I can. Yeah.
Afternoon, everyone. Welcome back. I'll just check everybody is with us. So Mr. Ferguson and Mr. Robinson, I can't see you at the moment. Are you there? Mr. Ferguson, hi. Mr. Robinson, hi. Great, excellent. That's us. Okay, so as I said, we've just completed item 3 on the agenda. So moving on to item 4, it might not take a huge amount of time. But there's some issues raised. Particularly, I want to give Mr. Ford the opportunity to expand on a few points made in his hearing statement. So, Mr. Ford, you've raised questions regarding, in effect, the Scottish Government's energy strategy and in particular the position on onshore wind energy. Could you give a very brief overview, first of all, of your position, and then consider the extent to which it would be within my remit and/or within the scope for Scottish ministers to take account of matters such as transmission network capacity, the peaks and troughs in energy demand, or any other sort of possible or perceived shortcomings in the system in a development management decision such as this. So if I hand over to you, by all means take a few moments to gather your thoughts again, straight after lunch.
Thanks. This really comes down to the current question about where this energy is going, or as I believe, not going. I briefly alluded this morning to the fact that we have 825 and 8258 megawatts of existing operational wind farms. We also have 4,648 megawatts of consented wind farms, which gives you basically just under 13 gigawatts of capacity. So when the wind is blowing, and this fleet of turbines across Scotland is producing energy, that clearly exceeds the amount of electricity that can be consumed in Scotland. And we know that from the Scottish Government's own figures, that's just under 3,000 megawatts in the summertime, daily average, and over 4,000, about 4,200 in the wintertime. So the question becomes, what happens to that excess energy? And at the moment, some of it flows south, perfectly legitimately, into England through the transmission lines. The problem, however, is that those transmission lines have a finite capacity. At best, it's around about 5.7 to 6 megawatts, and that's when the Western Link is operating properly. And it can, at worst, drop down to about 2 gigawatts, basically. So in that scenario, the question becomes, essentially, you've got a situation of oversupply. You've got too much energy that can't be used anywhere. So the question becomes, what happens to it? And what's happening to it at the moment is that National Grid are basically asking wind farms, and they compensate them for this, financially compensate them for this, to turn off wind farms in Scotland, because that's essentially the only way of reducing this generation. Also, bear in mind that we have about 2 gigawatts of nuclear fuel, nuclear power stations. So, you know, you could take that out of it and kind of move the baseline up a bit for that. But that's low carbon as well, obviously. And I quite accept that one of those, Hunterston, will go off stream sometime next year. Although National Grid are signifying that that will be fully replaced in the south of Scotland by some of that 4.5 gig that's coming on stream under construction. So the problem is whether Scottish Government policy recognises the full consequences of what it's trying to do. And this is where we get into the issue between Scottish Government policy and United Kingdom Government policy and what it's trying to do. Because United Kingdom policy not just recognises the overall climate change objective, but it's also signalling through some of the other documents, and I think net zero strategy, as I said this morning, is one of the documents where it's becoming quite evident. I think it's been evident to me now for something like 18 months, but it's becoming very evident in terms of the fact that they don't really want to put more infrastructure in to increase the capacity between Scotland and England. And that's fundamentally because the UK government, the regulator and Ofgem have a statutory responsibility to limit the costs to consumers. And essentially, in simple terms, the scenario the UK government faces is we have offshore wind energy coming on stream in the North Sea and Celtic Sea and places like that. And we also have the potential for more onshore wind energy in Scotland and a little bit in England and Wales. And how do they play this in terms of the costs to consumers? Well, in simple terms, all of the North Sea wind farms, so there's some big heavy wind farms going up to 2 gig being built in the North Sea, you know, but started building them, you know, they're coming online from 2 years ago kind of thing, and they'll continue to come online for the next few years. But all of those wind farms are connecting to the national grid system without adding additional cost to the transmission system. Whereas if you improve and upgrade the transmission costs, the transmission infrastructure between Scotland and England, that is a cost that falls onto the consumer. And that's essentially for 2 reasons. One is there is a thing known as the EU generation cap. And I'll try to remember, don't hold me to this exactly, but this is EU 838, I think, oblique 2010. And that, which is a EU-wide regulation, puts a limit on the amount of charge that can be given to generators averaged across the whole of the system. Okay. And what means,
sorry, Mr. Ford, can I just ask, does that still apply to the UK?
It does at the moment. There is clearly the potential for the UK government to withdraw that.
Right.
Okay. But what it's doing at the moment is that, off the top of my head, in fact, I'll get some figures for you. Let me just pull up a document here and give you some figures.
And that's fine, Mr. Ford. And in terms of the second part of my question, in terms of the ability for me to take this into account.
Yeah, I'll come to that.
Yeah, that's great. Thank you.
Sure. So in the last 5 years, the cost of operating the transmission system, okay, this is the national grid system, which covers Scotland, England and Wales, has risen by about 22.5% from 2,700 million to 3,300 million. And in that time, the renewables on the GB system have grown by about 17.3 gigawatts, so 17,350 megawatts. Okay, and that figure, and these figures about renewable energy are coming from the REPD database, which is our document 3. Okay. But if you split out that cost of the transmission system, you get quite an interesting picture. In Scotland, in the last 5 years, 4,170 megawatts of renewable energy have been added, which is predominantly onshore wind. The cost of the electricity transmission system in Scotland has risen in that last 5 years by 55%. So from £617 million in 2016-17 to 958 in the current year. Okay, in the same period for the rest of GB. Okay, and we know this because we have 2 operators, 2 transmission owners operating in Scotland and 1 operating in the rest of GB, which is National Grid. So in the rest of the UK, 13,178 megawatts of renewable capacity has been added. However, significantly here, in the same period in the last 5 years, the transmission costs for the rest of the Great Britain have actually fallen. So in 2016-17, the National Grid England and Wales transmission costs were 1.785 million pounds, and in the current year they've actually fallen to 1.755 million pounds. So in other words, the costs have actually fallen by 2%, and that's excluding inflation. So whilst the 4 gigawatts of renewable energy have added 300 million pounds worth of extra transmission charges, the 13 gigawatts of renewables in England have not added any costs. Okay. Now we have to bear in mind here that the UK government and the regulators have a duty to consider transmission costs, and they have an obligation, statutory obligation, to minimise costs. So there's obviously a grave question here about the role of Scottish renewables within the Great Britain electricity system. On this basis, it's clear to see why the UK government does not want any more intermittent energy coming forward from Scotland into England and Wales. We can talk about, you know, energy use in Scotland, but we also really have to talk about not just that, because of the oversupply situation, we have to also consider the GB system. Okay, but effectively, all of the additional costs of transmission to the GB's transmission system in the last 5 years have arisen in Scotland. And that's because the wind farms are spread across Scotland and they require additional infrastructure. Whereas in the UK, they're all connecting into the existing grid network. So if a wind farm in the North Sea is actually connecting to the heavy connections around Humberside, the old locations where the coal power stations were. And as a result of it, they don't need any more costs. They don't generate any more costs.
Okay. Right. So sorry to interrupt you. So in terms of bringing that back to the second part of my question, can I ask you to move on to that, please, Mr. Ford? I'm clear on the arguments that you've put forward, and you've given me quite a detailed.
Sure. Well, can I just make one point here before we move on to that, which is quite important,
yes.
Is that because of the EU generation cap, okay, only 25% of the transmission costs are met by generators in the UK. Okay, the other 75% is picked up by consumers through their electricity suppliers. Okay, and as a result of that, the generators, particularly in Scotland, are not getting the sufficient economic signals to tell them that actually we don't need this energy anymore. And if you look at the policy that's coming through with the flexibility plan that we've given to you, you can see that actually the government, the UK government, is directing Ofgem and the system, and in fact they don't need to direct them because it's already in statute, to increase the signals to disincentivize electricity generation from onshore wind farms in Scotland. And that's because of the transmission charging formula. Okay, I won't go into the details of the formula. I'm happy to do that if you wanted to, but this is not really the place. So let's come on to the wider issue here about what this means. The core benefit claimed by this proposal, by the applicants for this proposal, is that they are meeting climate change needs by generating renewable electricity. I fully accept that's a valid claim, okay? However, the problem is that they aren't actually going to produce any output, because what will happen is, because of this oversupply situation in Scotland from wind farms predominantly, all that will happen is that they will displace electricity being produced by other wind farms, and what will happen is the level of curtailment will rise in Scotland because of that. So the net effect of this energy, this potential, you know, if consented and built, would be that actually no net electricity will be produced. And that's because the fleet is, you know, all the onshore wind farms across Scotland are basically running as a collective fleet. They run, I can give you some statistics on this, but essentially you've got 55% of the onshore wind farms in Scotland, in southern Scotland, so that's south of the Forth Clyde Valley, and another big 35% block around the Moray Firth and so on. But essentially, the wind predominantly doesn't change greatly, and they basically run as a fleet. So all you're doing is adding to that fleet and to the fact that the reality is this energy isn't going anywhere. Now, this comes back to the fundamental point that we're here meeting electricity needs.
So, sorry,
point
Mr.
is
Ford. In terms of my question around how that relates to, so obviously we've spoken already during this hearing about what national and local policy tells us, and there's different views on the level to which onshore wind is supported. So, in terms of my question, in that context that you've just described, where does that, I suppose, where does that leave me? Let's be clear. So where does that leave me in terms of making a recommendation to ministers in the context of the policy that we've discussed?
Well, to be frank, sir, I think what we're saying is that the Scottish Government policy, I fully respect the ambition and the hope in it. But I did say right at the beginning of the day, we have today, and political ambitions and policy has to deal with the reality of the situation. The reality of this situation is that this energy is not going anywhere. And in terms of, if it was just meeting a Scottish need, okay, we didn't have an excess supply flooding down into England, then we consider whether that's meeting Scottish demand, okay. But we know it's not. We know it's exceeding the Scottish demand, and essentially this goes back to Mr. Campbell's legal point here this morning about what the responsibility for this decision is. Mr. Campbell said that this is a reserved matter, and it's being dealt with under delegated powers. So the Scottish minister, and this is I think the key point here, has to respect the fact that he's taking a decision not just in the Scottish interest, but in the GB energy electricity production interests, and thirdly here in the Great Britain consumers' interests, because essentially the only way that we can potentially use this energy that's might come from this wind farm is to increase transmission capacity. Now, I happen to think that's not likely to happen, but the reality is that this wind farm will increase costs to consumers.
Thank you, Mr. Ford. That's clear. Okay, so I'm going to open that up now to others to hear their views. Before I come to you, Mr. Hardy, I saw your hand first, but Mr. Campbell, obviously, because Mr. Campbell follows on quite neatly from Mr. Ford there. Do you want to add anything, Mr. Campbell? I can't hear you, Mr. Campbell. I think you're muted. Yeah, you are.
I don't want to, sorry about that. I don't want to give evidence, but I would like to put a question to Mr. Ford through yourself, if I may, so that I don't lead him on the matter. When you talk about transmission, you're talking about the physical carriage of electricity from Dumfries and Galloway into England. I think it may be important for the reporter to understand how that is achieved, whether it's achieved at present in any sense, or how it might be achieved if changes were made.
Okay, well, as consumers, as lay people, we tend to think that we just put the lights on, and at this level, we also know that electricity is being generated. But essentially, there has to be a connection between those consumers and the transmission of energy, and the generation of energy, and that's carried by the transmission lines. So there are a set of, in fact, 4 lines running between Scotland and England, and there are lots of lines running across Scotland as well, so things like the Bewley-Denner line and that kind of thing. And there's lots of lines running in England as well. So there are 4 main carrying lines between Scotland and England that physically carry the electricity. Okay, now they have a finite capacity, and you have to respect that capacity. So unless you change that capacity, you don't have an ability to move the electricity from Scotland to England. That's the key point here. I'm not sure I've answered your point, Mr. Campbell.
Yes, for the moment it has. Thank you. Thank you, sir.
Thank you. No problem. Thank you. Mr. Hardy, please.
Yes, I think you asked 3 times about relevance. That was, how does this, where does it leave you? The answer is none of that is relevant with respect and to your decision making. if there are matters that you are of interest to you, or indeed the ministers arising from what's been said, and without prejudice to our view that none of that is material to your decision making, then it would take would require some detailed written representations in response, because we don't accept what's being said. But I'll sort of ask you, so if you feel it is sufficiently relevant to warrant those representations, then we would ask for leave to put them in. However, my primary submission is that none of that goes anywhere to the decision that you've got to make, or the ministers have got to make.
But you have to say why, Mr. Hardy. I'm sorry to interrupt, sir. It's not good enough to simply be King Alfred and say, you know, or King Canute and hold the tide back. You've got to explain to the inquiry why it's not relevant. Mr. Ford has tried
it's obviously a
explain
consultation. It's obviously it's an informal hearing, Mr. Campbell. I'm not going to be cross-examined by you. Make my closing submissions. The reporter might want to look at paragraph 165 of SPP, and may want to look at the Falago rig submissions just by way of backup. But beyond that, and it was interesting, Mr. Ford wasn't able to give an answer to the reporter, notwithstanding he was asked 3 times about why any of that's relevant to the decision-making process that he faces.
Well, I'm glad you've raised that, and I'm sure Mr. Ford would like to come back in due course when he's given leave to do so.
Thank you, Mr. Hardy. Well, so Mr. Ford, I saw your hand then. Do you have any response to what you've just heard?
Essentially on this point of relevance.
Yes.
I mean, the foundation for what I've said is in our submission, in our first submission. And,
yes.
And my colleagues have submitted this as early in the process as they actually can do. The applicant has had a chance, A, to submit contradictory evidence or different evidence, or B, to escalate this to an inquiry session and to cross-examine me and to examine my evidence. But with respect, they have not. And therefore, at this stage in the process, my understanding is that the evidence I have submitted in the submissions is accepted into the procedure. And I mean, I fully understand Mr. Hardy's statement in terms of, you know, questioning relevance. To me, it's a bit of a Mandy Rice Davies statement. It's, you know, you've really not got anything else to say.
No, that's fine. Okay, so no, I mean, I'm clear on what your position is, Mr. Ford, and I'm satisfied that I have sufficient from the applicant in response. Obviously, there are the supplementary hearing statements as well, which go into this to some extent also, which I've read. So I'm satisfied with how far we've gone with that particular point now. So thank you. Just before I move on from that point, does anybody else have any points they would wish to make on that? Mr. Campbell.
I'm sorry to come back again.
That's okay.
If I may, Mr. Hardy has highlighted helpfully paragraph 165 of SPP, June 2014, and the Falago rig decision. Now, Mr. Ford has dealt with these in his submissions, but I wonder if you might be assisted by hearing his interpretation, his construction of section 165. Mr. Bell also relies on this as a completely closed door to discussion of grid matters. But actually, if you look at it, and I'll hand over to Mr. Ford because I don't want to give evidence.
Just bear with me a second. I just want to get that in front of me. Okay. Is there anything you'd like to add, Mr. Ford?
Absolutely, yes. I did think this might crop up, so and I've tried to prepare it in a kind of well, I've kind of tried to construct it in a quasi-legal way because I think it is quite an important point, and I think we should be giving the applicant an opportunity to respond. But let me first look at SPP 165, and I'll come back to Falago rig in a minute. And the reason for picking that first is that this is obviously extant policy. I accept that 165 opens by referring to, quote, grid capacity, unquote. And it obviously says that this should not be used as a reasonable reason to constrain areas affected by wind farms and individual wind farm decisions. And at first sight, that seems completely clear. But it goes on to qualify this by talking about it's for developers to discuss connections to the grid with the transmission owner. So perhaps it's not quite as clear. SPP 165 is really only talking about local and immediate connections from the wind farm or from a wind farm to the grid. It does not include the wider issues related to grid capacity. SPP 165 does not have anything to say and does not apply to or exclude consideration of wider grid issues such as the grid capacity between Scotland and England, or indeed anywhere else in the country for that matter. We can see this because in the final sentence of 165, it says, consideration should be given to underground connections where possible. So that's quite a specific tightening of what it's actually saying. So the scope of 165 is actually limited to the immediate connections between a wind farm and the grid. In this case, that's between the Sanquhar 2 proposed substation and the Grenglass substation. It has nothing to say about grid connection matters beyond that first link. So contrary to what Mr. Bell suggested earlier on today, and he suggests this in his point 2.2.4 in his supplementary submission, SPP does not provide a universal prohibition on consideration of wider grid matters for these proceedings. To me, 165 would be clearer if it started by saying local grid access should not be used, because that's really what it means. That's what 165 is actually about. And by way of background here, let me just give some context and some explain the situation. Wind farm developers, as well as getting consent for under Section 36 of the Electricity Act, also need to be able to connect to and use the electricity grid. This means that the developer needs to sign up to the Connection and Use of System Code, the CUSC, set up under the Electricity Act to regulate the industry. Properly licensed operators obtain a connection to the grid anywhere in the country. That can be anywhere. Perhaps surprisingly to lay people, there is actually no legal constraint about any location of connecting to the grid. So if a developer wanted to gain access to the grid on the top of Bain Nevis or Cairngorms or Snowdon in Wales, the transmission owner is legally obliged to provide it. I'm aware that this applicant has gone through that process for S2. After a proper application to National Grid, in which the developer gives the location and the required connection size, I'll come back to that later, the developer is offered a binding contract under the CUSC with 1, the cost of the local connection, 2, what are known as the enabling works that are required further into the grid to facilitate the development, 3, the first possible date for the connection to start operating, which will usually be some time ahead when the physical connection and the enabling works are all done. In practice, due to costs and the time of possible local connections and enabling works, developers tend to cluster their proposals for wind farms around existing grid transmission substations. So coming back to SPP 165, the point of this explanation is that it is always possible to connect to the grid anywhere in the country. That may be some years away and the cost will vary according to location, but it's always possible for the developer to connect to the grid. In some early applications for wind farms, there was often contention or debate about whether or not a proposed wind farm could connect to the grid. These proposals were often in out-of-the-way locations where grid infrastructure may be weak. Since it was a misleading issue, because of the legal obligation to provide a grid connection, and a grid connection was always assured, SPP at 165 seeks to circumvent any unnecessary contention by confirming the developer's right to connect to the grid anywhere in the country. But contrary to Mr. Bell's suggestion here and Mr. Hardy's suggestion, 165 is offering no guidance whatsoever and is not setting policy on issues relating to grid capacity issues beyond the immediate connection. Those, sir, are a matter for you to consider. So now let me turn to Pelago.
So, Mr. Ford, sorry, but before you move on there, could I give the applicants an opportunity to respond to what you said so far? Because otherwise we might cover too much ground.
Yep.
I mean,
Mr. Hardy.
So their matters. Of course, Mr. Ford and his advocate can make submissions. They're simply not accepted. They're not relevant. Mr. Bell has set out the response as much as we need to do. So I'm not going to say anything more about it.
Okay, Mr. Hardy, thank you. Mr. Ford, are there any other points on that before we move on?
No, I don't know. You've got any questions, sir, on SPP 165? I've certainly got more points to make about Pelago rig.
Okay, well, make those points now, Mr. Ford. I haven't got any questions on 165. I've read it and I've listened to what you've said there, so I'll give that thought in due course.
Thank you.
Okay, thank you. Thank you.
So let's turn to Pelago rig. The wording of the report at 3.108 is quite complex and with double negatives isn't entirely clear on what it actually says. Understandably, since these inquiries reports cover voluminous documents and lengthy proceedings, they focus on the fulcrum of the key issues. With all due respect to Mr. Bell's views here, Mr. Hardy's views here, as a reader of many of these reports, I'm not convinced that the grid issue was a key issue before that inquiry. Understandably, reporters rattle through the issues of lower importance. It is therefore dangerous to over-rely on such statements. But even if we interpret and adopt the imperative in the way that Mr. Bell suggests, the reporter provides no evidence or rationale for his comments on payments. I suspect if a court was asked to look at that particular element, which is one sentence in a 170-page document, they would find difficulty supporting the reporter because of the lack of reasoning alone. To the extent that I can decipher what the reporter is saying at 3.108, I might be inclined to agree with him. However, the issues being considered in this inquiry are different from those being considered at Pelago rig. You cannot carry over one reporter's views where he gives a cursory view on minor issues on one appeal to another appeal, to another decision. The circumstances may have changed. We know that in 2017, when this inquiry was taking place, the Western HVDC was coming on stream, and the reporter may have thought that that might have resolved the constraints payments issue. 3 years on, we know it has not. Let me move on to the minister's letter. Firstly, I need to correct Mr. Bell's, because of his comments show some imprecision here, and this refers to his supplementary submission at point 2.22. The Scottish Minister does not refer to, quote, grid matters, as Mr. Bell indicates. There is not some sweeping, all-encompassing remark about the whole grid situation. The reference in the Minister's letter on page 4 is restricted to, and I quote, constraint payments, close quote. I'll come back to constraint payments in a moment. 2.23, at 2.23, Mr. Bell says the Minister's letter at page 7, quote, agrees with reporters' findings. The Minister's letter does not say that, but the Minister does not go through all the findings. He uses a broad brush approach in a short 8-page letter to summarise the reporter's 170-page report. With all due respect to Mr. Bell and Mr. Hardy, there's an element of clutching at straws here to say that the Minister affirmed the reporter's view on, quote, grid matters, and that effectively that this represents policy or some ministerial edict, that all grid matters were thereafter ruled out of every other wind farm inquiry is frankly not at all credible. The Minister should not, and I don't believe he did here, make policy on the hoof. There is a process for making policy, and this was not it. Nevertheless, if the grid matters were so important as Mr. Bell implies, Why did the minister not even refer to the word grid in his letter? We don't even know whether the minister or his civil servant read this appropriate section in the report. But to say, as Mr. Bell suggests, that the minister consciously ratified the reporter's findings and specifically the detail of even constraint payments or the broader issue of grid matters is frankly beyond credibility, as I say, clutching at straws. However,
Mr. Ford, sorry, just a moment there. So in terms of how I will proceed with this case, I recognise that particular case is just one case, and I'm not bound by that, and I'll reach my own view. So I understand that point. Does that address your concern in that regard? That I am going to look at the evidence on its merits in this case. So
sure.
So I don't need convincing on that point that I'm bound by a previous reporter's findings in a different location as well.
Yeah, I accept that, sir. Can I just point out one other point here?
What is it? What's it about?
It relates to the fact that this is an EIA development, and as we know, EIA developments are covered by the law. And if we look at Wingfield versus Canterbury Council in 2019, which relies on the original case of Regina versus Swale Borough Council in 1919, considerable care need to be taken about the definition of EIA projects, so as not to salami slice the project in a way which excludes assessment of environmental effects.
Thank you, Mr. Ford. I don't want to go into that now. That I think that goes beyond the scope of the focus of the hearing session, and I think I've got sufficient information on that matter in terms of the adequacy of the EIA and its approach.
Okay. Can I just make one more point here, sir? And that is just coming back to this point about constraint payments, which I said I would come back to.
Just bear with me a moment, because let me just check my other questions. So I might pick that up. So just bear with me. So there might be a better way to bring it together. Okay, well, it might be helpful, Mr. Ford, to say what you need to say on the constraints payments point, and I can see if I can bring that back in later on if I need to.
Yeah, sure. It's fairly fine, and that is that I'm aware that constraint payments have been raised by several people in different wind farm inquiries. One thing I'm saying here is that, first of all, I'm not sure that the reporter in that situation actually understood the issue, which I appreciate you're going to take your own view on, sir. The second thing, though, is that is actually not the core of the point I am making here. Constraint payments are a symptom of the problem. The issue I'm actually raising in this inquiry is the oversupply of electricity generated by wind farms in Scotland. And that's the key point, sir. Thank you for the opportunity to present that.
No problem, thank you. Before we move on, can I check, does anybody have any comments or wish to respond to any of the points that Mr. Ford has made there?
So the only point I'd make, Mr. Bell, was obviously at Fallago Rig, and I'm sure it's for Mr. Campbell and Mr. Ford to make submissions, but we don't want to say anything. And we've got our written material, and our submission basically is none of that's relevant to you.
Mr. Hardy, Mr. Armstrong and Mr. Robinson, anything to add?
No, we've got nothing to add on this subject.
So in terms of this item, let me just review where we're at. So, okay. Did somebody try and get my attention then, or is it just the microphones making noises? No, okay, that's fine. Okay, so in regard to project benefits, the calculation of the carbon saving that would be achieved by the development has been been challenged by Mr. Ford's statements. My question for the applicant, first of all, is there a standardised or widely accepted approach for calculating carbon savings, and has the applicant followed that?
Yeah, so Mr. Bell, he can take this to start with.
Thank you.
Yes, thanks, sir. And I think probably the key reference will be in the additional information document, Appendix 2.2. The various assumptions and source documents are referenced in terms of principally carbon dioxide savings, carbon payback time using the Scottish Government carbon calculator, which is accepted in Scotland as the way in which to do that. So the references are there. So that's Appendix 2.2 in the additional information. So I don't have the exact document reference to hand, but I will get that. Someone will pass that to me, I'm sure.
No, that's fine, Mr. Bell. Yeah, I've got the references. Thank you.
So I would say that would be somewhere to look. Now, what is done in that appendix is that there's a range provided, because clearly we cannot predict exactly what the savings will be. But in terms of the three standard approaches, at one end of the spectrum, there is coal-fired generation, which is theoretical now because clearly there is very limited coal generation on the system. There is also a fossil fuel mix, which assumes a certain level of fossil fuels, but then there's the grid mix of electricity, which is a sort of medium take on it, and that is generally what is referred to as a fair approach. So the figures are illustrative, but the headline matter is the installed capacity that the development can bring. It is in line with the government's approach to generate renewable electricity, and there will be carbon savings. I've been at some inquiries before where there's been great debate about, will it be X thousand or Y thousand? And I think in the cases where I've reviewed those afterwards, the reporters and inspectors have said, look, there was a bit of debate about the exact figure, but the key point is that this development is renewable, it generates renewable capacity. That is in line with government policy. Now, I fully accept the Scottish ministers, if you look at the decision letters, often refer to savings, and it's important that you have that information for you to write that up as part of the benefits. So Appendix 2.2 contains those metrics. It also contains the carbon payback time. So the length of time that the wind farm would need to operate until there would be a net carbon benefit. So these are there. So the grid mix figure, if I can start with that, for CO2 savings per annum is set as an expected level of 307,881 metric tons. And the payback time for the grid mix is set down as 1.9 years using the carbon calculator. Now, the other metrics that have been used are the, this is really it's a helpful illustration about the quantum of benefit, is the households that could be powered theoretically by the level of energy generation. So again, Appendix 2.1 makes reference to that, and the figures are there, and I think I've referred to that in my hearing statement. For example, the equivalent of 335,489 homes. So I think that's what I wanted to say. That's the source in the EIA material for you, and the tables are quite clear with these figures set out, with the various assumptions and source documents behind them.
Thank you, Mr. Bell. Would anybody like to comment on that? Mr. Ford.
Thank you, sir.
Thank you.
I noticed that Mr. Bell emphasised the, quote, installed capacity. As I understand it, what they're saying is that this is 44 times 7 megawatts, which is 308 megawatts. The carbon calculator is based on the output, electrical output from the wind farm. And for some reason, the applicant hasn't provided an accurate figure for that. I'm aware of the fact that in connecting to the grid, as I've indicated earlier on, the applicant has to give to the transmission operator the size of their intended output. And this is known within the industry as the transmission entry capacity. And it's the basis that sets the maximum threshold that they can generate, and also is the basis for charging of the transmission charges. To National Grid, the applicant has told them that the electrical output of the wind farm is 250 megawatts, not 308. All of the subsequent calculations that Mr. Bell's outlined are dependent upon that 308 figure. And I am raising grave questions about the validity of that. Secondly, in my submission, I have queried the load factor that's been applied here, which also affects the electrical output from the wind farm. And that's covered in my submission 2.1.9, where I've compared the output from the turbines that the applicant is using here, and I believe they're quoting using turbines with a blade diameter of 150 meters. I do note that yesterday somebody on the applicant's behalf was referring to 117 meters, but let's just go with 150 meters. And if you compare that to the adjoining proposed wind farm at Yukon Head, who are also using 150 meter diameter wind turbines, they are producing 6 megawatts per turbine, and they're basing their calculations on a load factor of 35% rather than the applicant's 45%. And as I set out at 2.1.9 in my submission, sir, that effectively means they're claiming to produce 50% more energy per turbine than the adjoining developer. Now, let me just set some context here. My understanding is that the applicant runs wind farms, operates wind farms with something between, I don't know the numbers off the top of my head, but between 100 and 200 megawatts, something of that order. The adjoining wind farm developer is a company called Scottish Power Renewables. They are one of the leading wind farm developers in the UK, if not the world. No, not the world, just the UK. They are a very experienced developer. I believe they might even be the first wind farm developer in Scotland on a utility scale. They have, as far as I understand their numbers, something like 10 times the installed capacity of the applicant. They are therefore a far more experienced and more knowledgeable developer. And I simply question the presumption that the applicant is making in this case, claiming to extract more energy for the same diameter of turbine for literally, well, in fact, to say it's next door isn't actually quite right, because these two sites cross over each other. On the south end of this project site, the adjoining wind farm is to the west, and on the north side of this proposal, the adjoining wind farm is to the east. So they're very close. I mean, they do align each other, got contiguous boundaries. So I think it's reasonable to assume that the same wind conditions apply to both wind farms. But that developer's got an entirely different basis for doing their calculations. So I do think there's serious grounds to question the applicant here. Thank you, sir.
Thank you, Mr. Ford. I don't know who wants to respond, whether it's Mr. Bell or Mr. Hardy. There's a couple of points in there in terms of how the installed capacity, as predicted, has been calculated based on the turbines selected and also the load capacity point.
Yeah, probably. I'll start then. Mr. Bell can come in. First point is back to paragraph 165 of the SPP. Effectively, grid is a matter of developer risk. So in terms of the decision making, land use matter, land use planning and electricity act. So that's the first That's the first point. The second point is the headline capacity is a good way to understand and indeed compare the scale of benefits. So the scales which have been used, the metrics which have been used, are absolutely standard, and there is there's nothing unusual with that, and you've got the ability to compare that with other schemes. In terms of capacity, I don't know, Mr. Bell, whether you want to add anything.
You're muted, Mr. Bell.
Sorry, I knew it would happen at some point. So in terms of the capacity factor, the developers' confidence level around that, because the developer's been operational by way of the Sanquhar wind farm since July 2018, and has data for 2 operational years as wind data, and the energy yield assessment that's been undertaken by the developer has also drawn upon the 3 local temporary met masts on and just off the side. So it's not that it's just an assumption made. It has very much been based on operational data from the existing wind farm and the expert technical team examining the specification of the turbines proposed, and also adding in the data from the met masts. And certainly in all the energy yields I've seen that go to get a bankable project and one that will attract finance, it is that type of solid analysis grounded in facts about the site itself that is important to give that level of confidence. So I think on that basis, the way the figures have been calculated using that gives you, sir, a level of confidence around describing those benefits.
And to press you, Mr. Bell, on the installed capacity prediction of 308 megawatts, if that's calculated at based on a 4 megawatt capacity of the candidate turbine, obviously you don't get to 308 megawatts. So could you just say a little bit more about that?
But the turbine that may be selected as about 7 megawatts. Siemens of a turbine at the moment is around about 7. And we're talking about 2024. Technology is advancing at pace. So I simply don't see an issue with that.
I think so. It's 7.
7.
I may have it may have been just a slip, but of course it's 7 megawatts. I think you said 4.
Yes, I did.
Yes, that's why. If you did it, if you used 4, the maths wouldn't work.
No, that's why I was asking.
If you use 7, then it does.
Mr. Ford, please.
Just a quick comment on that, sir. I keep a database of turbines available through the world as part of my research. As I said, I'm an anorak. I apologise for that. The 7 megawatt turbines that I can see on the database all start with 155 or mostly actually over 160 meter blade diameter. I appreciate technology is moving forward, as Mr. Bell says, but I'm not sure that there is a turbine now or likely in the future that is going to fit that specification of 7 megawatts of output against 150 meter blade diameter. And that is simply because we are, or rather the applicant is pushing the limit of what's known as the, I can't have to remember what the law is, but there's a law of physics that basically says you can only get so much energy out of a wind turbine depending upon its blade capacity. So there's two concerns here.
I think it's called Bet's law, Mr.
Sorry?
I think it's called Bet's law, isn't it? Bet's
law, that's right. Sorry, BETZ. And that uses the 1627th rule. That you can only ever take 16/27ths of the total output of potentially going through the rotor diameter of wind energy. And I can explain that to you mathematically, sir, if you want me to, but I suggest we don't go there. But then there's a second factor behind that, which is the how close you can get to that. And realistically, you can only get to 80% of that. And actually, if I've done those calculations preliminarily on a preliminary basis, and I think there is some doubt physically in terms of the laws of physics here that you can get that amount of output out. So I do think there's some doubt, and Mr. Hardy, I appreciate saying what he says, but the facts here can be tested, and it's one of the reasons why we put in the documents for the Ukenhead wind farm, which is adjoining, going through a similar process a bit later in the process. But they're a very experienced developer. I think it's fair to say, if I had to put my bets on anybody, I would rather take them than this applicant, simply on the basis of the credibility of the information. Thank you, sir.
Thank you, Mr. Ford.
Well, I mean, I obviously, on behalf of my clients, I think that's a rather offensive comment, because that's suggesting that somehow there's unreliability on the part of my client. They are extremely experienced, and there's nothing that Mr. Ford has got to actually gainsay what we've said. There's a bit of speculation on his
The
part.
facts that the wind farm are actually in the evidence?
Mr. Ford,
adjoining wind farm?
I'm not
Sorry,
going to be questioned.
I didn't actually capture that, Mr. Ford. Sorry.
The facts of the adjoining wind farm are in the evidence.
Irrelevant to the point I was making, sir. I was just, and also, we've got to try and help you. The evidence from this developer on this scheme, based on the evidence from its existing wind farm on this site, the adjacent site, is as has been set out. So, you know, that is the evidence of the applicant, and just on behalf of my client, I don't take very kindly to the idea that somehow just because SPR is SPR that they are better or they're more honest or whatever it is than the applicant. And if Mr. Ford did mean that, then I think that's unfortunate.
No, that wasn't intended, sir. It's just
right.
All I was pointing to is their far more substantial experience.
Well, I don't agree with that either, Mr. Ford. This is an extremely experienced developer with lots of spinning turbines. Second point is in relation to the application, of course, it's an up to figure, so as you know, so there is a cap at 200. So it's an up to. At the moment, there is a 6.6 meg machine. That's a Siemens. There are machines coming out all the time, and the confidence by 2024 is that there will be a machine which is very, very close to that. It's already approaching that, but the cap, if you like, is the 200-meter tip.
Well, actually,
I understand. Thank you, Mr.
I would just say, actually, there's a 16 megawatt production turbine coming out, but that's for offshore.
Well, when I'm talking about onshore, Mr. Ford, let's just stick with the real world. And this application, in this location, there's a 6.6 available, and as I say, we're 2024 confident, but in any event, it is an up to application. There's no minimum requirement to produce 308 anyway. So I think so far as that your consideration, so that's all we need to say.
It's just that the output is critical to these calculations of carbon and homes served.
It's just that we must have a constant. We must have a constant for the calculation. Either it's 250 or it's 308. It's not somewhere where Mr. Hardy puts a pin on a map. And the applicant needs to be clear what it's putting forward.
As I say, you can make your submissions, Mr. Campbell and Mr. Ford, but the evidence has been given. Thank you very much, Mr. Campbell.
Whilst we're on that point, I'm just checking a reference that I'd noted down for my own notes, and has been very slow to open whilst we've been talking. So just bear with me a moment, because I just want to check what I jotted down there. No, that's fine. That's fine. No, that's all clear. Mr. Armstrong, please.
So I'm just slightly concerned where the applicant is going with some of this, particularly in having regard to Mr. Denny's evidence earlier in the week that obviously the worst case scenario that he was considering. And just on the point about the 7 megawatts and 7 times 44, We are, of course, here talking about 42 turbines at 200 meters max and 2 turbines at 149. Is the applicant suggesting that the 2 turbines at 149 would be generating the same amount as the 200 meter turbines?
It's no concern, Mr. Arms. There's worst case has been assessed, and Mr. Denny has based his LVIA. So in terms of the EI envelope, that's been dealt with, but it is an up to figure. So it is, and obviously it's behaving on the developer too, and it will maximise capacity. But there's no cause for concern on your part at all.
Well, I wonder if you could clarify the position as that there's 42 turbines at 200 and 2 at...
Yes, that's the assessment. That's an up
149.
to. And if there's 2 which don't make that, well, it'll be slightly less than that. But at the moment, that is the envelope.
Yes, but it's not as simple as just saying 7 times 44, is it?
Yes, it is. There may be 2 that aren't in terms of 7, but at the moment, that is the assessment that's being that we're asking the reporter and the ministers to consider. That is what's on the table.
In terms of the candidate turbine that was used for the noise assessment, what's the installed capacity of that turbine? So that's the Enercon E138 EP3. It's a catchy name.
That's a bit of factual information I don't have to my fingertips, but I can look that up. I can certainly take instructions. So if that's...
Thank you. Yeah, I mean, that would be helpful because obviously we've got, we've got a turbine being assumed to be used for that purpose. So it would be helpful to know that.
Perhaps we can come back to that if we take. It is. I note it's 2:45. I don't know whether we're going to take a short break at some point, but or else we're going to go on till we finish. But I can certainly come back on that.
Thank you. Are there any more points on that particular matter? No. Okay. Well, actually, perhaps inconveniently, that's the end of my questioning. Actually, on that under item 4. But before we conclude, first of all, are there any other matters under item 4 that anybody would wish to raise and they don't feel they've had the opportunity to do so? No. Mr. Ford.
One point we haven't discussed is the alternative sources of renewable energy. And obviously, there are plenty of alternative sources. So there are plenty of ways of meeting this need for renewable energy from other types of renewable energy, from other wind farms in other locations. So when it comes to looking at need, we obviously consider location and the need itself. So if there was 308 houses in Edinburgh, for example, we would probably clearly accept that there's a need for that. But if there's 308 houses it's 250 houses in Knoydart or the Flow Country, we would say there wasn't a need. So we do consider a locational perspective to need, and that the need can be delivered. There's no point in building houses in Edinburgh if they're not going to be used. You wouldn't create the effect, and that situation applies to this proposal as well. Thank you.
Thanks, Mr. Ford. Yeah, so this is obviously a distinct point from the council's views on site selection as such, in terms of, is this the appropriate site for a wind farm? This is a question of actual, is this the appropriate means of meeting the energy needs at all in terms of a wind farm? Is that correct?
Yeah.
Yeah.
And this location.
And its location. Mr. Bell,
Yeah,
is that your hand?
I'll pick that up. So it's not material. Again, it is not something for you. So the question of whether or not you could configure this site differently, or indeed whether you could have this site on this scheme on a different site, are not considerations for you. And what you've got to do is look at this scheme in this location against the criteria in the Electricity Act. That's an end of it.
Mr. Armstrong, do you have any comment on that?
Sorry, I'm happy to save that to closing submissions, but it does seem rather extraordinary submission to make with no backup for that. But I'm happy to leave that to a matter of closing submissions.
Then I'll provide the case law on that, Mr. Armstrong, of course, if that's an invitation.
Okay. I don't have any further questions for you, as I said now. So, Mr. Hardy or Mr. Bell, do you have that information to hand about the Enercon candidate?
Not yet. No, I'm afraid we don't.
Okay,
We're obviously busy doing other things.
Yeah, yeah. No, that's fine. I didn't know if anybody had passed you something or anything like that. I thought I'd ask whilst we're still on the call. Okay, so before we conclude, I'll give you, if you wish to have the opportunity to make any final comments or remarks in terms of the evidence that we've heard today and the discussion we've had, then I'll give you that opportunity. So, Mr. Armstrong or Mr. Robinson, do you have anything you would like to say in summary?
Sorry, I think our submissions are clearly set out in detail in the hearing statement for this session, and also in the report to committee, and I don't think there's really anything else to add to that. That is a very thorough submission on these points.
Thank you. Mr. Campbell?
Yes, I think my position is the same, sir. You have a hearing statement, a supplementary statement, and then you have Mr. Bell's responses to those to set against them. And you will note carefully that he hasn't dealt with the central features which Mr. Ford has advanced. However, I'll keep that for closing submissions. So I'm very much obliged, but nothing further to add.
Okay, thank you, Mr. Campbell. Mr. Hardy, please.
Good. We don't need to deal with things which aren't relevant to your determination. Obviously, that would be our submission. Beyond that, sir, no, there's nothing that we need to deal with. Thank you.
Okay. Thank you. Well, can I thank you all for your input and your participation today? It's been quite a long session, so I appreciate your time today. So that concludes hearing session 1. So tomorrow we have hearing session 2 for those of you who are involved with that. So we'll be starting at 10 AM again, and that's focused on the conditions and possible legal agreement. And then after hearing session 2, I shall close the inquiry formally. Okay, so thank you again for your time, and I'll see some of you tomorrow. Thank you.
Thank you. Thank you.
Bye.